Bon dia, buenos días, good morning.
Good morning. It's amazing to see you again back here in the second day of this fourth edition of Consumer Arbitration, the fourth international conference. And here we are at the Distrito Administrativo in Catalonia. Also, hello to everyone following online. And our website is jornadesarbitratgeconsum2025.cat. Great opportunity to be updated with everything. We hope this is a very fruitful session. We have 3 roundtables. One will start immediately and the other 2 after the coffee break. And I hope that we have a high participation like we had yesterday, that you can ask whatever questions you have, share your doubts, and we will speak about many things that already emerged yesterday and some more. How arbitration affects us, consumers, or how the EU does it as well. It will be truly interesting. So without further ado, we will start with today's first roundtable with the title Consumer Arbitration, a key tool for agile, effective, fair, and accessible resolution. We will have Alicia Menendez as moderator, Deputy Director of the Secretariat of the Council of Consumers and Users. We will have her on stage. So hello, Ms. Menendez, and the following participants: Tiziana Tallaro, General Director of Confianza, online. She will take her seat. Thank you, Tiziana. Juan Manuel Velázquez Gardeta, President of the Consumer Arbitration Board of Euskadi. Thank you for being here. And Xavier Hormigos, President of the Transport Arbitration Board of Catalonia. So, let's listen to these fantastic participants. The moderator will tell you have around 5 or 10 minutes, depending on the questions that we have, and then we will have the coffee break. So, you have the floor. Hello, good morning, everyone. Firstly, I'd like to congratulate the Catalan Agency for Consumer Affairs for organizing this session and the way they are treating us. I believe we can start discussing, and hopefully we will be able to have an agile and very powerful discussion today. The title of this session, as we were saying, is Consumer Arbitration, a key tool for agile, effective, fair, and accessible resolution. Behind this title, there's no doubt the need of going deeper into whether it's the consumer arbitration system that we have as is truly effective, fair, and agile for consumers and traders, and whether it would be more effective for arbitration to somehow become mandatory, absolutely mandatory, or perhaps just resorting to what the law on transports did. What happened with this law on transport arbitration after the ruling of the Constitutional Court? So things will come out. I won't. Well, almost everyone knows about my legal position, but the fact that I have one does not mean that I don't agree, and I remember Mariló a lot here, in the building, or her building, of how mandatory arbitration could be possible for some services. This legal opinion that I have of the impossibility of establishing a mandatory arbitration, I mean fully, is, well, remembering Mariló and the fact that Mariló, we could have different opinions, but she had a legally valid construction which became modulated throughout time, and it's a shame she can't be here. I need to warn you that I'm eager, I'm quite passionate, and well, this does not mean that I totally oppose. I believe that in the light of the ruling of the Constitutional Court, it's absolutely impossible to go towards mandatory arbitration because I believe it's a legal equivalent and not a legal truth. The other day, I spoke to a colleague, and the fact that we move forward in a not too far future towards a different position that is more open and that allows consumers to further facilitate the possibility of having alternative dispute resolution mechanism. Having said this, I will start asking the first questions to the different participants. So firstly, I'll ask Tiziana. She's director of Confianza Online. And we haven't seen so much of each other lately, but we have actually quarreled or discussed a lot in the last 15 days. She belongs to a company association with an ethics code, and different companies trading with goods and services through e-commerce adhere to this code of ethics. They have a mediation committee, which is ADR, to solve conflicts between users and traders, notifying to the EU and the consumer boards, the first ADRs that become notified. And they have vast experience in dealing with claims, with the difference that they are a business association. They do it through mediation. We do it through arbitration. And things change quite a lot between mediation and arbitration. So I wanted to ask, why, and this was the case, but why do you, in your code of ethics, establish for companies the obligation that once the mediation procedure that you do is over, the one that you do in Confianza Online, this goes to an arbitration board as in a second attempt to solve in a different ADR, as long as there's an agreement by the administration performing the arbitration. So what is the reason you want to guarantee consumers or force traders? Well, they're not forced if they don't adhere to the code of ethics. But what is the reason, basically? Can you hear me all right? Sorry for my voice. I have a bit of a flow. Thank you very much to the Generalitat, to the Catalan government and the Catalan Agency of Consumer Affairs for the invitation and having me here with Alicia, because we've known each other for many years. She's a great professional, friends, mentor, and I'm delighted. I shouldn't say, but I'm saying it. I'm delighted to be here with her and with the other colleagues. So the question. Confianza Online is a private association promoting best practices online. And when Confianza Online was born, there was some codes of conduct put together, self-control for the part of advertising, particularly for digital advertising that was just starting. We're speaking about 2002. And then Digital, which was the Spanish Association of E-commerce, also decided to join efforts and codes, and they created these three elements: the code of conduct of Confianza Online, then the seal, the trust mark or seal certifying adherence to the code, and an extrajudicial dispute resolution mechanism, which at the beginning started to operate with the different companies who were part of Confianza Online. It was a sort of legacy coming from the associations creating Confianza Online. At first, we had like telecoms back then. I remember Telefonica. I remember El Corte Inglés back in the day, companies that were part of digital and self-control, and they started to be part of Confianza Online. On the following year, that's when they sat down together with the Institute for Consumers, and online mediation was taken more seriously and more rigorously. So how can we do this? You cannot force companies, of course, because we are a self-regulation body, and self-regulation is on a voluntary basis. But our code of conduct wanted to go beyond this point, and at that time we decided to create a stronger bond with the code and with the dispute resolution mechanism beyond our mediation attempt. That is when the famous trademark agreement was signed, which was the one used up to 2021, if I'm not mistaken. And there was the obligation for companies that adhered to this Confianza Online's code to abide by not only the mediation agreements that could be reached through Confianza Online's mediation, but also if these agreements were not reached, then they would be subjected to subsequent arbitration, but only in those files or cases that had previously passed through the mediation attempt of Confianza Online. So the idea here was to offer consumers a third level or a third attempt to protect their interests, first with a customer service with our mediation attempt secondly, and with a third instance through consumer arbitration, and provide companies with the security that if they not underwritten an adherence clause to this consumer principle, their whole activity would not be under the compass or of the arbitration, but just exclusively the case that had been overseen by Confianza Online. So the company had the assurance that they already knew the case, they knew the file, and they could know what was going on, because if they didn't know or didn't know what was going on, we were giving them the obligation, but also the assurance that this obligation would be only limited to these specific cases. So after the COVID pandemic, the trademark finished, and what we had back then since 2012 was a fabulous relationship with the Community of Madrid department, and we redrafted our agreement with them, and we thought, all right, so we no longer have national coverage because these claims were not going to any region, but rather they were going to the National Consumer Arbitration Board. That's why Alicia and myself have a long-standing relationship. And since we no longer had this national coverage and consumers in the entire region were not offered access to consumer arbitration equally, then we said, okay, so let's once again design a national coverage. So we started with the Community of Madrid. They accepted to slightly change the agreement and to subject all claims from citizens in Madrid or for consumers in Madrid to come to our mediation first, and then if the mediation did not manage to solve things, then we would offer arbitration. And it's the consumer who needs to send their arbitration request. So that's how we started to knock on other doors, other regions. Here we have a fabulous agreement also with the Balearic Islands, Aragon, Castilla-La Mancha. And this is news, but next week we will have a meeting with Konsumovida, and in coming months probably with Murcia as well. So what we want is to avoid any sort of discrimination because of a region where the user lives. And through the Confianza Online code, they can access, we cannot force everyone, of course, but at least in these cases, they can have an access to arbitration. Well, this is quite striking, but I've always thought, why do they accept arbitration? So in the code of ethics, they accept the arbitration of some board. It used to be all boards and now some. But these companies, precisely some of them, and I'm going to say generally speaking, but I've never heard of an arbitration in a bank, but they are adhered to Confianza Online. And also, amongst our great deniers to arbitration, El Corte Inglés, they never wanted to know anything about arbitration. And I imagine that since they are a company association, they are more trustworthy. I don't know. Well, it's because of what I was saying before. They somehow keep a certain amount of control. They're not going to lose control. Well, you know that arbitration boards, there's many in Spain. And there's not just one arbitration board. There used to be just the national one. But you don't choose a board because of its quality. No, I'm not saying that. I'm saying that the fact that the claim has been channeled and it's solved through the mediation of an impartial third party, so through ADR in this case, and if in this case it's not solved, then they are subjected to arbitration. It's not the same than having a consumer presenting requests for arbitration because he has not been properly serviced at a store and God knows what they want. I don't know. I have a hole here in my jersey. Well, yes, but if they tell you and they tell your service has been poor, yes, but it's a way of having control. Yes, but they know they need to go to customer service before they come to arbitration. Okay, that's something that we're going to leave there. But the second question is, how would you see the mandatory character or the possibility of establishing a mandatory consumer arbitration from the perspective of Confianza Online, or the assumption to a certain extent of an amount, perhaps, of being subjected to arbitration? Well, my personal thoughts are that, but you're always speaking about the code of Confianza Online through the code, or no, generally speaking, of course. I work essentially with the digital part. So my personal struggle, not the effective one, but at least my heart struggle or mind struggle, is that I don't think it's correct that the adherence offers to the arbitration system need to be global to all activities in a company. Nowadays, and I believe we spoke about this when the framework agreement was about to finish and expire, but there's some different arbitration pathways. E-commerce represents 20% of retail business. It's e-commerce, so we've gone from 7 to 20% in 10 years. And as you know, this is increasing by the day. So as we have some specific rights for consumers in the legislation related to e-commerce, why not create adherence offer just for e-commerce, for the digital activity of a company, but not as a whole, not the company as a whole? Speaking of Corte Inglés, for instance, it's not the same to have a person go to the physical store, to a shopping center, to just buy a product in terms of rights. It's not the same than buying the product online. So why should the obligation of arbitration be global for the entire activity? That is the question I have. Well, we're not going to go in deeper, but now that we have the royal decree moving forward, having all companies sharing the same same number in the registry, the e-commerce, which is the same commerce relationship or trade relationship with some little differences, it wouldn't really make sense. But I do understand your position because this is your business, obviously. I'm not saying it in a negative way, but, well, we were talking about Corte Inglés being subjected to arbitration, partly thanks to the Code of Confianza Online, at least for the e-commerce part. If you force them to subject their entire activity, they would probably reject the idea and even unsubscribe from Confianza Online. So we would miss the opportunity. No, you would never be able to reach arbitration like that. Well, thank you very much, Tiziana. Okay. Well, she's already introduced herself. So now we have Juan Manuel Velázquez, President of the Consumer Arbitration Board of Euskadi. I know the board through the secretary for a long time. And as lecturer, I wanted to ask you whether consumer arbitration, mandatory consumer arbitration for all disputes within our constitutional mandate, or at least for conflicts stemming from general interest disputes. General interest services, well, this is a very wide concept, obviously. Apologies, but he's not using a microphone.
Bueno, bon dia. Moltes gràcies per la
Good morning, and thank you very much for the invitation. Thank you. So, very briefly, I'm delighted to be here. It's a true pleasure. I do ask you to invite me more. Very happy to be here. So, going to the question, I have here my notes. As we answer the question, I wanted to mention some inclusions and comments. This is the important thing now for me. This is important discussion points, the mandatory nature of arbitration. Far beyond consumption, because arbitration as a dispute resolution mechanism has two worlds to it, the world of consumption and the rest of the world. The rest of the world, with vast amounts of money in many cases, is always addressed at entities where companies choose the arbitrator, and there is controversy on impartiality, and this would be an entirely different conference. On consumer arbitration, we all know the legal framework, constitution, laws, tells us that effective legal tutelage 117.3, judges can execute their rulings, and if we go there, we would have that arbitrations are not no jurisdiction and have no jurisdictional power, and therefore it cannot be so. Arbitration cannot be so. So we would be there in a very constitutional scope. But I've, in my answer, gone for a more extensive and flexible perspective. Bit controversial as well, if you wish. Otherwise, we can just close up with the Constitution. But it is true that there are some other laws that speak about the concept of justice in different terms. There should be prompt response with real transformation of processes. And this law, the Code of Civil Procedure, takes us in my arguments to focus on three different rulings of the Constitutional Court that you all know about, 174/9075, that declare as non-constitutional Article 38 of Law 16/87 on mandatory arbitration in transport. The following, which was 352/2006, that allowed, with a different wording, 16/87 amended this and had a different wording and allowed for that arbitration. But if no intervening parts had shown their will to go against. So the one I'm interested in is the third one, the ruling 1/2018, 2020, sorry, where there's two particular votes, or at least three. One is a joint vote and the other one is a separate one. There's Valderfe and two other magistrates. I'm particularly interested in because that does open a door to something we could call mandatory nature or non-requirement of previous agreement. The ruling, as we know, somehow declared a law of insurance as non-constitutional. The insurance holder had or was entitled to any difference that could stem from the contract, and the appointment of arbitrators could not be done before the dispute was established. So with the particular vote of these three magistrates, we could open up a new pathway. In the end, everything is a political matter. Laws are drafted in Congress, but there is some sensitivity here because these magistrates focus on the matter not depending on the wording of the article, but rather on what we all believe, which is the unbalance between the consumer or the retailer or trader. There's lack of balance, adherence contracts, standard contracts. And here there's something, there is an imbalance here, so let's try to strike this balance as far as the contract allows for. And I do believe there's some will by some magistrates, at least in that ruling, to try and somehow polish things a bit. But there's also an interesting reflection. Jurisdictional power and tutelage. There's no effective tutelage in arbitrators. If there is an appointment of parties that is absolute, then there is judicial protection or legal protection, and in this case, there's no legal protection. So is the arbitrator going to hinder the company's possibilities? I'm being a bit controversial here. You can have your own opinions, but this is what the magistrate of a particular vote or individual vote says in ruling 1/2018. I said 2020 before, apologies for that. It's 1/2018. Doing a very wide reflection, this is also protection. And then there's the jurisdictional review. So do we review the only things that can be reviewed, or do we go in deeper? If we allow for things to go in deeper, then we won't go for arbitration. Some things will just stay with the awards. This is basically prospection. If we do the review of the three reasons, we are playing a different level. So one thing comes hand in hand with the other. If we have mandatory arbitration, what review can we have in future legislation? If we admit or accept, the High Court of Justice in Madrid is no longer going to review. If we go for mandatory fund, yes, but I was saying that if we go for mandatory arbitration for everything in consumer affair, what can you actually contest or dispute? This is what Marilo said when there should be recourse against. Well, I know I opened up a new door here because with the constitutional framework and law stemming from it, there's no possibility. But with this new individual votes and reflections on the figure of the consumer and effective protection, legal protection, there could be an expansion. This subsequent consequence is what can we appeal of those mandatory arbitrations? Are we also going to change the sense of the appeal? And as regards to draft bills, or if you go into amendments of royal decrees, going over, in level 7/2007 was the transposition of the ADR. basically states it needs to be or have a voluntary nature unless a specific law can force someone. We included this in the draft bill at the ministry, just in case at some point we had this temptation of going for a mandatory arbitration, and that actually happened, but we included it once again when drafting the regulation back in 2024. And unless a legislation or law establishes such and such, and there we explained that this was basically due to the legislation in the power industry, and basically it states that they need to be adhered to public ADR known by arbitration boards. And immediately we had to some things happened in Law 7/2007 and not here, but I do agree that we will move forward, especially for the sustainability of justice, just because of that.
The issue of the resources, if the arbitration courts have them, fine, or the other jurisdictional entities. And then the second question, would you be in agreement to establish the presumption when the transport law clearly says that with the protection of good faith, it's not necessarily for the consent to be explicit and clear, but rather it can look at different behaviors of the entrepreneur, of the business? Well, I personally believe so. But we'd have to see if the presumption is a legal presumption that's included in the law or if it's in the hands of the consumer. It's opeligis, that is, if it's written in an article or if it's in the hands of the consumer to say, all right, depending on what the consumer says, then it can become mandatory in some cases. That also has another consequence, which is the recourse of ordinary justice. Well, what are we going to do to review the if we have the mandatory presumption of arbitration for up to a certain amount of money, but accompanied by resources on this, of course, would harm the power of the arbitrator, because if we ask for a recourse, but I don't understand that. Why a recourse? Well, right now you cannot question the arbitrator's decision. I call that the I call that the essence, and if it's accepted and then to manifest that it's not accepted, in that case, the only recourse would be to say that there's been a clear manifestation, a clear behavior that is wrong. Well, we modify the law here, and this presumption is installed. What you're asking me goes to the government, and the government allows that. There's no recourse on constitutionality for certain amounts of money. It's the presumption of arbitration. But if it's done in a general way, well, it cannot have a consequence, which is the possibility of a recourse based on the essence. They don't have any possibility for recourse. No, they don't. And if the other day I was responding to a question. I said, I imagined, all right, if there's a recourse to Luxembourg, because this goes against the 2013/13 with the presumption of mandatory nature, and you go to an ordinary judge and you say, okay, is this a right that goes against the European Union? Well, I'm not saying that I'm in favor. I'm just being the devil's advocate here. These things can happen. Yes, of course they can happen. Yesterday I was talking to some colleagues that I was involved in the directive 11/2013, and the arbitration went forward, and we have the director of the Braga Center here with us, and this went forward because Spain and Portugal said all right, and France said, or they accept the mediators that I have for companies, or there's no mediation in transport, because in France the arbitration of consumption is unconstitutional, so they had to accept the company mediators, and there's quite a tradition, but for France to do that, I mean, that's striking. Well, the article that we're talking about, if none of the parts had clearly expressed to the other their desire against, I mean, it leaves a margin there to manifest your disagreement. And it says it will require the participation of these arbitrations as long as this does not keep the parties from having their rights protected. And so in the same ruling on the law of transport, well, I think it is quite clear. It makes it clear that the desire, that the will has to be clear and explicit. And concerning the essential goods, or those such as energy, telecommunications, we're seeing lots of arbitration on that. Yes, it's true that the majority of the cases, even if we have the presumption, the large telecom companies, they are participating, but the large energy companies, they've all adhered to this, even though they didn't want to, with attempts to get out of it, but with impossible recourses towards resolutions of limitation. But in the end, they don't dare to, because the Commission on Competition follows them very closely, because they have to offer a means of conflict resolution. It would cost them money if they win. So always in arbitration. So thank you very much. And now, finally, Xavier, I don't know why I had it wrong, and then I thought about it again this morning. Since you have experience in these things that we're just beginning to explore, one of the things that I ask myself is how transport companies are less than the universe of companies involved in transport in all activities and sectors. How can you do you have some kind of a registry? How can you follow up and to know against the presumption of the acceptance of arbitration? That's important, because if we consider all of the companies having adhered to this, and for them to destroy that presumption, how can you control that? Or do you have to do that in each file, in each case? Well, it's 1018. The topics that we have dealt with are, well, they're humongous, they're huge. We have taken on some extremely interesting and current issues, but we've talked a lot about the presumption of submission to arbitration, but I'm not sure if they know all over the world what we're talking about. And to focus this a bit, to talk about where we're coming from, and Juan Manuel said that if we remain along the lines of the Constitution, the debate is over quickly, because those two rulings that he has mentioned, well, they dealt with an imposed, mandatory arbitration dictated by law, so it's mandatory as is included in the constitutional courts. Now, this, 174/95 that continues to be in effect in road transport in the framework of the Constitution. There are Articles 24 and 117 cannot be questioned, and so in transport after 15,000 euros, I need an agreement between parts, and less than 15,000, you need for the agreement that goes against this. That means a concert of desires, and if not, it's a mandatory arbitration. So that arbitration was considered unconstitutional. The arbitration that currently exists, it's an arbitration that is supposed. It's a presumption, but it is not mandatory, because sometimes, well, they say that arbitration is mandatory in transport, but it's not. 352/6 leaves that very clear, makes that very clear, and it insists on the fact that that we have from the public prosecutor, and it's not mandatory because any one of the parts, and I could answer here, any one of the parties can oppose that arbitration. But what does occur is that it restricts it in a certain way to a period and to certain amounts. The amounts, well, we can talk about that later. When the second ruling came out, we're talking, there was a modification of the regulations. It was at 6,000, now we're at 15,000. So it's very relative as to what is a low amount. Either of the parties is allowed to have the possibility of arbitration, and we shouldn't forget that this is a right that has to do with legal regulation. It's not a right that is absolute, but one that the legislator has the possibility of configuring, and thus these particular votes and the activities of the needs of all of the contingencies, because justice, as was saying, if it's not rapid, then it's not justice. We have Law 1/2025, which is goes in that direction. And now I'm going to say that there are other arbitrations that are mandatory, they're regulated, and no one has looked at them. They're not mandatory in that sense of the word, but tell me if it's not mandatory or not. The law of road transport imposes all of the companies that provide public services and that want to participate in different lines. They have to be subject to arbitration, and you can say, all right, they could oppose it, and then it would just be non-compliance of a contract, and that would be at an administrative level of what was signed with the public administration. But I think it's quite it's quite obliging, and Law 14/2002, so it's been around for a long time, and it says that the companies will submit to arbitration in the case of cable. It's not the same as consumption, but I'm sure that if we dive deeper into this wide repertoire, we'll find things that even if we don't identify them as mandatory arbitration, we could see they're present. Well, are these arbitrations that are administrative? They refer directly to the transport. I'm talking to the sector that I'm familiar with. I don't know the others. I know a little bit about the others, but these two laws in particular, one is a law, the other is a rule, and I think it's probably one of the regulations that, because of the modifications that it's undergone and what has been introduced, it's a regulation that's almost at the level of a law. It takes into account that 68.2, Article 6.2, the companies that have concessions and that want to participate in public lines for regular service of transport, and this is what we're talking about, the laws of general interest. In the laws of general interest, I think that in effect we could establish some kind of arbitration, presumption of arbitration without any problem. But how do we control this? How do we follow this? Well, step by step, we have an arbitration court. And if in a specific case there's a document that supports that party has informed that they don't want to undergo arbitration, well, then all the documentation is there. We're not going to restrict the means of proof from a what's up to a email or a clause within the contract or a clause after the contract. But isn't the manifestation before the conflict arises, doesn't that have to be done before then? Yes, the manifestation has to take place before the activity. We can sign a transport agreement. I can buy a ticket for the train, for example. These are general conditions, but we could have a contract, and until the service is provided, then I have time. Well, that's one of the factors that have been criticized in the ruling of the Constitutional Court. It temporarily restricts the possibility of denying submission to arbitration. And as we look, you have the possibility of denying submission to the arbitration until the service is given. Yes, if we go to the contracts that are celebrated in massive ways and that include these clauses, those are the general conditions. What do we do then? Well, we make sure that these general conditions, and you know much more than I about this, that it's been correctly informed and has been accepted on the part of the consumer, and that's all. Well, I remember shortly after the reform of the transport law, one day on the beach in Huelva, a station in Huelva. I don't want to remember what it was like, but there was a large sign where they sold the tickets that says, "We do not accept arbitration." That was right there at the ticket counter. And well, we'll have to go to all of the different businesses and put that in their windows. This is real. Well, on some transport tickets, on the back there was a clause that was included of acceptance of the transport arbitration. But that information has to arrive before the service is provided. If you have a clause on the back of the ticket and you have paid for that ticket, well, then it is taken for granted that you've been informed. Now, but there's that regulation I talked to you before on the public service regular lines that belong to the state. The different conditions are included, and we cannot have a discretional service under that. Well, if we look at the offer to adhesion, we could substitute it with the list of the opposition to the presumption. It would be with that opposition to the presumption, we would see. Well, when we talk about the consumer, the colleagues in consumption, well, they say there's a list of those that do not adhere to arbitration. But there are very few of these. There are very few companies that include these concepts, and we talked about it before with Julia and Uriol, because we have a slight advantage, because transport arbitration has its history not since 1987, but it comes from a long time ago. The legislator back in the 19th century and at the beginning of the 20th century made all of the parties that participated, that possibility. The I think that arbitration of transportation, well, the Department of Transportation feels comfortable with that because it does not require the presence of lawyers. It does not condemn you with the costs. So why wouldn't I go to the arbitration in transport? So what better guarantee will I get from some mercantile process that has many material, and if there's a specialized court in this, and let's not forget that there are representatives of their sectors, of the corresponding sectors. We are a court, and we meet with a representative of the consumers, another one from the transport companies, and also with the president, who is a civil servant of the public administration. So that leads to trust from the citizen that says, well, if there's a representative of the consumer association, they say, well, at least they know if there's an abusive clause, they'll know about it. And the same, the transport companies will say, well, we have a representative of the transport sector, and they're not going to leave us hanging. So in our arbitration, we draw from the inspiration of the conflict between professionals. And since the profession was already used to going to the arbitration board with their peers, well, they don't have a problem of going there as well to resolve the conflicts with the consumer, because they know that the norms, the regulations will be applied, and there are spokespeople there that know about this issue. There are very few companies that include non-submission clauses. There are two companies in three in transport. One is train, two that are and one is road transportation, two of car rentals, and we fortunately are competent in the handling of those complaints. Well, you have them, yes, you already have them, but the association, for example, when I'm talking to the president of the Catalan Association, he says, no, we want to continue in the transport arbitration because you have won a reputation that you don't deserve, because people think that in the Office of Consumption, everything will be in favor of the consumer and that you win everything. I'm sorry, that's not true. I try as much as possible when I have the opportunity to defend my colleagues that are consumer arbitrators, and 99% they solve the situation, and they are experts and highly professional. They are as objective and neutral and impartial as a transport arbitrator. So I think that there should be formulas that we explore in certain sectors of general interest that can turn to arbitration. Now, this is another debate, and I know I'm going over my time, but we would have to see if our courts are the adequate ones, because our court, with the procedure that it has, with the difficulties that there are for the constitution of the court, I mean, it's not appropriate for doing claims for 50 euros. We have to be imaginative and say, what other mechanisms can we have to be truly rapid, to be truly effective? If I need three arbitrators for a complaint about 50 euros, well, it's bad news. Yeah, but we can't do that, and I don't know if you could or not. Well, we are advancing little by little. Yes, but I want to say that nominally the law of transport says that the arbitrators will be impersonal. Well, I want to remember that it was in the law. It talked about the paritary equivalence, and in many cases it's anti-economic, totally anti-economic, and it's less. It's not as agile, not as quick. If there's an association of consumers and they dedicate their workers to that, then it's a cost for them. Let me finish. The organic law one from 2025 that deals with the resolution of conflicts. It can't be an excuse for the problems of the administration of justice should be seen in that way. That's another topic altogether, but the lack of means that they have, that affects us all. Are we going to be able to face all of this? Well, they're going to have to provide us with the means. Well, I think we've gone 5 minutes over. I don't know if we have 5 minutes to be able to ask any questions. Anyone from the audience? Thank you very much to all of our speakers. It's been quite interesting.
Sí. Pero espera un momento que no tenemos micrófono. ¿Quién tiene el micrófono?
No, tú ya tienes.
Sí, no, pero quería presentarle porque es compañero. Sí. Pues es verdad. Yo lo tengo, es verdad, qué tonta soy. Ya lo puedes.
Okay, you can use this against me. But Professor Tomia, that is president of the board, arbitration board of Cantabria, and we have a conflict going on with them, but he would like to ask us a question. Thank you, Jorge. Good morning to everyone. I wanted, first of all, to thank Alicia for her wonderful presentation and to thank the Catalan Consumer Association for this wonderful meeting, this wonderful conference. But I wanted to give my opinion. Well, we have people that think that we fight with each other, and we even used to go to the same beach when we were young, but without knowing it. But I wanted to say something very briefly. I'm not going to give a counter conference about mandatory arbitration, and I think it is the situation for the coming years, and I wish it were only for the coming months. But the correct approach to this, to take this topic on, is not the jurisdictional equivalent, in my opinion. It is an invention of Sara Dominguez from '98, where it strengthened arbitration as the alternative to judicial jurisdiction. Now, this sentence of '98 that was celebrated with champagne by the people in the world of arbitration, I remember those articles of Bernardo Carmadas and Fernando de Rozas, that was used in recent years, in the last decade, by the Supreme Court of Madrid to have a game of tennis back and forth with the Constitutional Court, where they rivalized to see who knows less about law. And it's a war between very powerful entities to see who knows less between two people that know very little. I know that I'm going to promote a bit of debate here, but let me give you a spoiler. In the 8 or 10 days, I'm going to publish a book which is called The Mandatory Consumer Arbitration. It's edited by colleagues. It is over 200 pages, and I take advantage of talking about my book and suggesting that you would do me a favor if you bought it, especially taking into account the debate proposals. And the proposals that I'm putting forth that comes from another idea, which is what Javier Orduña was talking about yesterday. He's one of the best jurists around, and he said that the key is in finding a pondered counterweight in Article 21, the protection, the effective protection, and the other one on the legitimate protection of the rights of the consumers. These are the economic interests in second and third generation, so the consumers have the right for them not to be poisoned, for them not to be blown up, and for them not to be cheated or scammed. Even the banks, even though the courts of justice don't know this yet, or at least they pretend not to know this. These last rulings, which are scandalous concerning the IRPH, well, I analyzed them in the book. So, of course, I'm still doing some advertising here for my book, but 24(1) and 51 have the same constitutional support, but they don't have the same constitutional level. 24(1) is placed in the basic rights and public freedoms, and 51 is in those in the legal structuring, and so that's not the same. It is like jurisdiction and arbitration. Given the use that is being done of that expression with the Court of Justice, it's a jurisdiction. We can walk around Paseo de Gracia and see the Pedrera building, and there Arroyo Mendez or Mendez Arroyo had their office there. There was very important lawyers many years ago. They defended in their manual the jurisdictional nature of arbitration, and same as Jordi Nieva, the same as the processualist. But this is not the question. The question is the ponderation, and how can we find a channel that with this Article 24, it can bring together 24 and 51, Article 24 and 51 of the Constitution, and that can overcome the barrier of the Constitutional Court and the barrier of the Court of Justice of the European Union. So it says this is adapted to the directive of 2013 because it says that it can be mandatory by law but allowing for effective release. What does the Court of Justice of Madrid look for? Where it's looking for a perverse interpretation of 41, talking about the control. It allows it to be included in the content. And this is clearly specified in the jurisprudence. The decision of the right of assistance can be provided in 14 days or 25. This can be an arbitration of equity, but remember that the arbitration of equity requires imperative law, and therefore we cannot elude that. Not only must it be used as a support, imperative or dispositive, it says it in the law 1717. So from this point of view, where is the clue that allows us to see how we move forward in that case? In the book, I analyzed 3 options. Once again, my book. And first of all, to go into depth in the bidirectional nature. It's bidirectional if we look at transport, because it's between companies. In the verticals, it's not bidirectional, but it doesn't claim to be. Well, sincerely, as a protector of consumers, bidirectionality is a heresy and it's a perversion of the system, but it's in the rules of 24 and in the convention. Yes, it is. Well, Juan Antonio Colmenero says that the arbitration of consumption is bidirectional because it allows for the convention. But let me continue. The most important thing I haven't said, but very briefly, I'm the one that gets in trouble later. The second is the presumption of transport. The irrevocable, it is not a position, it's a revocation. It's another channel that is advised. And the other is the mandatory arbitration. When is that applicable? Well, we have to analyze in what way the action to annul without getting into the essence is a sufficient requirement for that constitutional mandate and the European mandate of having access to justice, to the ordinary jurisdiction. And it is very complicated. I'm not going to explain this now. The book comes out in 8 days, 8 or 10 days, but one parameter. I'm finishing. Because based on the quantity, and there are certain quantities that are examined, and also because of the reason for the activity, and this is where we analyze the economic services of general interest. And in the scope, it's a concept that is very defined. Jolly Blinton wrote an article. Okay, thank you, Jorge, but we cannot continue. Thank you very much for everything.
Por último, quería...
Finally, I believe you wanted to add something. Well, I would have liked to attend the presentation. It's in Cantabria, basically. I don't know if you can attend. Well, I don't want to be too exquisite here. We've increased the level, the legal level, but here I was talking about rights. I consider, as a friend said, that the rights of protection for consumers, it's under construction as effective legal protection that can also be or undergoing construction is more established. The consumer rights is undergoing constant construction in a building. We have not reached absolute guarantee, right to physical integrity, right to life. Well, that's where we're going to. And jurisdiction, it's not proper to say here, but offers the creation of jurisprudence, and the High Court of the EU basically is pro-consumer, extends margins and scopes. I don't know whether they will reach any deliberation or statement. Apologies, but he's not using a microphone. Yes, but the Court of Justice in Luxembourg is carrying out their task, and all I know are basically in favor. National courts are different story. Okay, thank you very much. Okay, so we're going to finish, and I want to thank everyone. This is one of the best sessions I've been in for many years, and thank you very much to Mr. Tomillo, the presenter, who's given us his opinion, and we wish you success. Thank you very much.
Gracias. Gracias, Alicia.
Thank you, Alicia. Thank you to the other participants as well. Thank you, everyone, for this very interesting roundtable. And, well, there's been book advertising as well, which fits into the topic of today. So, anyway, we have around half an hour now. Please, for coffee break. And we will resume in 30 minutes, so please be on time so that we can continue with
Hola de nou, benvingut.
Hello again and welcome everyone after this very fresh coffee break. 5 degrees in the morning, 7 now. I believe this is good for our minds and to be able to share and participate in these roundtables that we have now. In this roundtable that is just about to start, we will speak about the mechanisms that consumers have to protect our rights whenever we have a dispute with a company, particularly if it's a utility company or basic service company, which are the most conflicting ones. And in this time that we have, we want to open up a discussion around how do we believe that arbitration needs to help to improve customer protection and consumer protection, not only here in Catalonia, but also in the European Union. This is what we will speak about in this roundtable. You can participate, also asking questions to our participants. So now I'll call them. We'll have Alexandre Briard of the European Consumer Organization, BEUC. He's here. He's coming onto the stage. Then Xenia Escudar-Gillet, lawyer at the Organization of Consumers and Users of Catalonia.
I també tenim en Jordi Sánchez i Picanyol, director de Dret.
And Jordi Sánchez and E. Picanyol, Director of Social Rights at the Catalan Ombudsman. Welcome, and I'll be moderating this session. I'll be here with them, and we will start speaking about everything related to this consumer arbitration. This roundtable has a title which is How to Promote Better Consumer Protection. So what we'll do, in order to have time for everything, and so that the audience can ask their questions, I will ask a question that will be common to the three of you. It'll be a question with sub-questions, and then I will ask an individual question to each one of you, specific to your fields. So, the common question would be the following: how do you value this proposal of mandatory arbitration for claims of under 2,000 euros. What are the pros, cons that you find, and what would be the main hindrances and limitations that you can find? Jordi, I have you right here by my side. No, you have to activate it.
Sí.
Molt bé, molt bon dia.
Hello, good morning, and thank you very much. Part of the debate, well, we also held this discussion in the previous roundtable, and it's been of a high quality. This won't be my perspective, my legal perspective. I'm no jurist. And I believe it's also interesting to introduce other elements that are not strictly rooted in this legal perspective only. The first thing that I want to say, I don't want to be controversial, but I do want to speak about this. Oftentimes, we are based on an idea that is mostly right, but not always right. And this is that there is an association between arbitration and consumer defense. I believe this is an element that we need to take into account, particularly when we are thinking about mandatory arbitration that can have effects of loss of possibility of a second review or of access to legal protection. I don't want to go into the discussion on whether arbitration is a jurisdiction or not, but this is an element that we need to take into account as a risk element. Secondly, and very much related to it, there is something that is a bit of a mistake and that we need to bear in mind when we speak about possibility of mandatory arbitration. The consumer starts based on a principle that is not correct, and that is that there's a perfect understanding of the situation. And let's be cautious because very frequently consumers are perfectly unaware of the rights and duties that we acquire with the different agreements established when we purchase a train ticket, for instance, with the previous example. I don't know about you, but I can assure you that I do not read anything, and I'm not at all aware on whether I need to withdraw or not withdraw from some subsequent situations. Anyway, speaking about mandatory arbitration, I believe that this necessarily entails some information procedures for citizens, for users, for consumers, which I believe are very difficult to achieve with their optimum perfection, of course, but I'm sure that we can do much better than what we're doing today. And here there needs to be a clear awareness of what denial or the basically waiver or effective waiver that we were mentioning could mean. The third element, well, we frequently say or believe that the field of arbitration guarantees or will guarantee a speed, a promptness that is not guaranteed by the world of courts. So let's be very cautious because the mandatory nature of some situations in some fields of consumption or with some certain financial amounts should not end up collapsing the arbitration boards or spaces, because we wouldn't be solving one of the issues that we know are underlying. So what do I mean by this? As with everything, it's not just about drafting a law or legislation, it's rather about knowing how we apply some principles, because if we truly want to be right next to the consumers, they need to guarantee what nowadays cannot be guaranteed by the field of courts. And finally, the third consideration, which relates to the first one, and that's all from me. Let's be vigilant as well, because if we go for arbitrations or arbitration procedures that cannot go to jurisdictional fields or review of essence, as we were saying before, and we go to arbitrations with no boards, well, this is an element that we also need to think about and weigh, because we might be limiting, in a way, some rights that the consumer could have through other pathways in terms of review or some other aspects. So having said this, I believe that arbitration, let's look at the positive side of things, the bright side of things. It has lots of room for improvement and development. We need to be very much aware of the inequalities. An arbitration between companies, as we saw before in the world of transport, is not the same as having a citizen against a company. There's a huge inequality here. And also legal lack of knowledge on behalf of the consumers. And here we need to be able to establish weighing mechanisms that can offset these objective imbalances that we find. And it is a great instrument that is providing great results. And we're now seeing that if mandatory nature is not accompanied by resources, by proper information and guarantees for the consumer, may end up producing not the opposite effect, I'd say, but an effect that is less positive than what we might think arbitration could bring as a mandatory, with a mandatory nature, I mean. So a very interesting comment. Arbitration is sometimes more complex than what we believe. So Xenia, same question for you. How do you value this possibility of having a mandatory arbitration, pros and cons, and the main difficulties or hindrances in your opinion, Xenia? Well, my perspective stems more from experience, perhaps a more social perspective, and I would like to speak about the issues that we find at the consumers and users organization in the face of mandatory arbitration. We see there's a lack of culture, not only in consumers, but also in companies. On the side of consumers, whenever they approach us and they introduce the problem, we explain mediation, and then we explain arbitration, they're struck. They don't know what arbitration is. And if they know something about it, it's totally mistaken. So we need to explain what arbitration is, the role it has, what are the main principles. So once the consumer has been informed, we provide this information, and then we move on to the issue of lack of knowledge on behalf of the company. Companies, because of their own opinion and experience, are afraid of arbitration because they consider it a risk, and they might not make the most of the possibilities of arbitration, such as the speed it offers. It is a faster pathway than that of courts, and this is a bit daring, but customers are not always right. And if customers are not always right, this must be or might be the fastest way of solving or proving that the customer is not right. It could happen, and therefore it's easier to go to arbitration and not allocate more resources to basically courts, which will take longer. On the other side, we want to say that the Organization of Consumers and Users of Catalonia do advertise arbitration a lot. This is what we try to disseminate information on this pathway. But despite this, we see that based on our experience, we're not really reaching with this information, reaching our targets. And this is more of a feeling than a conclusion, but if arbitration became mandatory, we might not be able to solve the volume of cases received. This is my own experience. I've been consumer arbitrator for around 2 years, and 1 month ago, I had a case dating back from 2023. And we're not saying that the person delivered the information late because mediation was done in January 2024. It's now November 2025, and the hearing is taking place now. I don't know about the capacity of the organization. I'm not aware, but we do need to say that we are informing partners and consumers in general that to present an application will take around 6 months when you get back some news, and perhaps the hearing won't take place after 1 year later. So if this is the situation that we have without it being mandatory, I believe there is a lack of resources personally, and I believe that this should be improved, as happens with human resources and financial resources. And then, on the other hand, I would also like to mention the issue of access and digitization. Digitization has obviously been a very significant leap in step, because this has allowed us to have several hearings on the same day of, I don't know, one in Cerdañola, a different one in Tarragona. This allows us to hold many hearings, but we find aged consumers, and some friends tell us, I'm from a small town in Tarragona, but imagine an 80-year-old person with no driving license, and they need to go 30 minutes to UNIT, and they need to perform the application and do basically the arbitration application. So how is this person going to go there? I mean, they can't use technology. Perhaps there's no good internet or connection in their town. So digitization is very good, but perhaps we need to improve the social point of access. And finally, I'd like to say that there's another company lobby that we find, particularly in essential services. There's a lobby there that would perhaps present some financial reluctances, and we should be able to sit down with them perhaps and speak about these things. And that's all from me. Yes, you've given us practical cases, Tenia, so that we can understand things better. We can land all the issues, and it's true when you speak about older people. Sometimes they can't use technology. Bureaucracy is also very difficult for them, and so we need to make things easier so that everyone can have access to this type of mechanisms to be able to defend our own rights in all towns and at all ages. Very interesting, your conclusion. And for Alexandra, I'll also repeat the question, because I believe you had problems with the translation before. So the same thing before. How do you value this possibility of having a mandatory arbitration for amounts of less than 2,000 euros, pros and cons, and difficulties with its execution?
Buenos días, good morning.
Good morning.
Gracias por invitar.
Thank you for inviting me.
I chose the wrong language during my studies, so I have to switch to English. Thank you for your understanding. So I represent BEUC. BEUC is the umbrella consumer organization. We are based in Brussels. We have 45 consumer groups. We represent 45 consumer groups before the EU institutions from around 30 countries. In Spain, OCU, Azufin, and SECU are among our members. And myself, I worked a lot in this area as a researcher. I did comparative study, comparative research on mediation and ADR, not in Spain, unfortunately, but in France, in Belgium, in Germany, and in the UK. So I've been following the developments of this field for several years. So to respond to your question, I will make 4 points. And I will give you the European perspective. As you all know, the directive in 2013 left the question of compulsory participation of traders open. Basically, it was up to the member state to decide whether they wanted to make ADR mandatory, yes or no. Some countries took that possibility. For example, France, my country, it's mandatory for businesses to sign up to an ADR scheme. Italy, it's also mandatory, Portugal, and so on and so forth. So it's either mandated by law, required by law, or it can be required not by law, but because traders are part of professional organization, which requires them to sign up to an ADR entity. So this is the situation. In Europe, it's very scattered, meaning the rules are very different. So it's quite a piecemeal. There was, many evaluation reports showing that the situation is far from being ideal. I give you a concrete example. Our colleagues from the UK, which have reported several times this situation, in the aviation sector, ADR is not compulsory. What happens in this sector is that you have a company called Ryanair. Every time they have an unfavorable decision, they leave the scheme. They say, we disagree, we leave. There is no mandatory participation, so we don't continue. So it's very difficult now, consumers, when they have issues, well, ADR is not part of any ADR scheme. Then if you look at the financial services area, where participation is compulsory, here it works very well. There is a clear route for consumers where there is a problem. So I think it's quite striking to see this comparison between a sector where ADR is voluntary, aviation, versus a sector where ADR is compulsory, financial services. As you know, it was discussed yesterday, there is a revision of the current rules, and BEUC took an active part in the discussion. I agree with you, this raised new challenges for ADR entities, the number of complaints and so on and so forth, but the reality is that ADR is often the only solution for consumers when something goes wrong, especially for small value claim. So we actually tried to make the point with the EU institutions saying ADR should be mandatory, maybe not for all sectors, but at least for key sectors, for the sector where we know there is a high number of complaints, like aviation, like transport, like tourism, and where we know there is a high consumer detriment. For those sectors, we think it's important that ADR is mandatory. I must say that the European Parliament was very receptive to the argument, and they followed us. But then, as you might know, in the final compromise, there was no mandatory ADR participation at all. It was left to the member state back to zero. So, but it's interesting because if you look at EU legislation, you already have EU legislation making it mandatory for traders to participate in ADR proceedings. Energy. In the energy sector, it's mandatory for companies to participate in the ADR sector. The DSA, Digital Services Act, it's also compulsory for traders to sign up to an ADR scheme. So there are examples of EU legislations making it mandatory for traders to participate in ADR. Why I think it's very important, at least for those sectors, this highly problematic sector, why it's important to have it mandatory for several reasons. Because as you said, I think very rightly, it's a question of access. It's a question of access to redress for millions of consumers, access to remedies as well, but it goes beyond. It's a question of trust, building trust with traders, also awareness. If you don't participate in ADR proceedings, you will never have a chance to know how it works. You will never have a chance to get familiarized with the work. So I think it's very important. Now imagine what we have seen in several countries where ADR is not mandatory, is that you have many and more private entities like claim vehicles, created to gather consumer claims. So for example, in the transport sector, you have small businesses where consumers must pay a fee, and then the company will handle everything for them. Okay, this is something that the ADR entity can do for free. So countries where ADR is not voluntary, you have this proliferation of what I call private claim management companies, help, transport, so on and so forth. This is the reality. I'm not sure it's good for businesses, and it's definitely not good for consumers. I stop here.
Gràcies, molt interessant la...
Thank you very much. Your contribution was certainly interesting. And it's all about knowing about the different mechanisms that can be used to improve all these lacks or details that are missing so that this arbitration can be possible. And we also see that conflicting companies are the same in Europe as here in Spain. So basic services, transport, and it's basically working. We need to continue working along these lines. Now I'll ask an individual question more related to your field. Jordi, you are closest to me, so I'll start with you. How would be, or what would be the best system to attend to the claims that you get by users, to serve these claims? What would be the best ways, I don't know, your wish list? How could we truly solve all this problem that exists all around Europe, not just here in Catalonia or Spain? Well, for starters, we need to say that the defending institution, the ombudsman, well, we only have some specific effect, those that's related to general interest services or basic services, no more than that. And as you probably know, ours is not a binding action. This means that the company does not need to accept the recommendations that we do in the face of a conflict between a citizen that has presented an application within the competencies framework against a particular company. Some people say, well, it should be binding. Recommendations should be of mandatory compliance. We say no. It may seem weird that we ourselves are saying no, or that it shouldn't be mandatory. But I believe that we need to properly understand the role of the institution, and therefore we don't have punishment capacity, coercive capacity, or impositive capacity. The culture of ombudsman plays a different role here, and in our opinion, it is a good thing to maintain this tradition and this culture. There are different bodies with different roles and some other rules of the game. And therefore, despite having citizens that do not understand this sometimes, it's worthwhile maintaining as it is. Secondly, what do we see? Well, generally speaking, there's a good relationship with companies, and they mostly cooperate with their requirements. And I would say that there are some very specific aspects. I'll just give you an example because we're tight on time. Oh, we're fine with time. Okay, then I'll give you two examples then. Okay. So, some aspects that, well, situations where we find a certain degree of, well, quite frequently, and, well, with goodwill could be solved.
Most of all, for example, talking about energy, when there is a complaint because someone is not happy with the additional billing or additional costs that have been billed. And we're not talking about a scam here. We're just talking about an improper functioning of the meter. Well, the companies have their inspections, their inspectors, they send them, they look at the meter, they analyze, they, according to their reports, they see that there's some kind of a problem with the meter, they redo the invoice, they fix the problem with the meter, and often this is done without the presence of the consumer, without the consumer being involved. Therefore, if we were in a criminal court, well, it wouldn't be acceptable, and the customer discovers that they can't ask for someone to come and decide if there truly was a problem with that meter or not. So this is an issue that is quite common, and we believe that with a bit of goodwill we could overcome that. Another one that's even easier to overcome is this is basically affect the gas companies when they send the announcement that you need to have a revision. They have to send someone to check all of the gas pipes and etc. And a date is given for that review. And when they show up, if no one is there to open the door or allow them to get to the meters, then they cut off the gas. What's the problem? Well, the problem is that the request for that appointment is done on normal mail. So we have no idea if that person has received the information that on that day, at that hour, they're going to come to carry out the inspection. So we find that the consumers are unprotected. Today, I've already spoken to the director. We're going to ask for an arbitration for the breakfast that we just had in the refrigerated area of the building. But temperature has dropped. I had a few complaints yesterday of people, since the temperature has dropped, whether they're elderly or not, because after all, that doesn't really matter. And people that whose heating is cut off, and they don't know why. And when they call, it's because the inspector was not able to get in at the accorded time. So we don't have mechanisms to be able to give the opinion that certain guarantees were not provided so that the individual can defend his or her rights. So the companies from here have not paid attention to us up to now. So these are two examples that we can consider. But I would say that there are companies, and this is true, it depends on the companies, and large companies often, where in 2 or 3 days they can fix any problem. If this can be interpreted as good practices in the world of business, well, we would be happy with that. They resolved many of the complaints very quickly, and we're talking about the complaints about anywhere between a couple of €100 to a couple of €1,000. Now, under 2000, we had been talking about, which would be the compulsory arbitration. When that cannot happen, I would like for you to explain what is your experience, Shenia, in accompanying your members when they go to court in this type of situation. Well, first I would like to give a brief introduction of what it is that we do. And that is that we often find in the consumer organization that the majority of the claims that come to us are from basic services. And the first thing we try to do is mediation. A company may say no, or we can try and insist and we don't get, and then we push for consumer arbitration. And what's the problem there? Well, we find that this company has not adhered to that. It is voluntary, and the company can accept it or not. And if the company has adhered to this aspect that we want to send to arbitration is excluded. So what do we have left? Well, it's going to the legal system, going to our court system, so we can have a direct intervention. And what we do is to inform, and we prepare the complaint or the claim. We look for all of the possible proof, and this, of course, is if it's less than 2,000, we don't need to have a lawyer, but we always recommend going to a litigating lawyer because there are large companies that have a very large and powerful legal department, and we also give them emotional accompaniment. What do I mean by that? Well, someone that comes from a negative response from the first claim from the company, a second negative response from mediation. It may or may not have been answered. And finally, the consumer arbitration, they may not even want to try it because they figure that it won't be accepted or that that specific area is excluded from the arbitration and they're told that they have to go to a civil court. So this is very intimidating, and that lack of knowledge, and they say, I have to go to without a lawyer, and answering this is more direct, and we can see that in the cases that we've been able to refer, the consumer has had the courage to go, and they discover that it's an experience. I wouldn't say that it's sad, but that it is slow, it is costly, it is very disappointing, and it's very unmotivating. We're not just talking about the economic cost and the fact that they have to go to the lawyer or all of the trips to us for advice, but it's also an emotional cost. And people feel lost. They feel totally lost in the midst of all this. And of course, there's an important investment of time. Now, apart from this, that's on the one hand, it's the judicial way of doing it is not the best one. If it's less than 2,000, then it is a technically simple process, but we are facing a court that they see what's on the paper and they don't understand anything at all. So not only do they not understand, but they are very lost themselves, and they feel lost, and they feel totally intimidated by the company. Now, we have a scale, and we have often found that it can be positive in those cases where we have gone through the court system, and we have found that the result has been totally or partially positive. But once again, we have to look at the negative side. It doesn't depend only on the jurisdiction, but also on the capacity for resources for the consumer and the proof or the information that can be provided by the customer. And before we heard talking about the law/25, and I wanted to say how it has affected us in consumer area. When there is a claim, they had tried mediation perhaps, or just the claim of the customer himself or herself. We can anticipate that we haven't found any problem with this because we always send the cases, and in this sense it's been positive. But we have also found that we have colleagues that go to certain courts that are more restrictive, and perhaps just with the claim of the consumer, even though it was sent by Burofax, that is not sufficient because it does not include the specific word that they are reclaiming the complaint. And there are some that decide not to adhere to the arbitration. And this means that not only does it affect the consumer with those companies that are not adhered, so it's not obligatory, it's not compulsory, but sometimes they say they just do not accept it. So it is rejected, and this speaks of a strong resistance that come from the smaller ones of public services, and that continues to affect the companies, the companies that have an important litigated power, that have large legal departments, and they want to keep it in the courts instead of going extrajudicially. And in this sense, and I'll finish with this, we believe that from the world of association, we want to promote. We want for it to be compulsory even under 2,000 euros, because we see that the judicial path is not the way to go. Everything, there's a lack of protection for the consumer and the feeling that the consumer leaves with. And if I can just say one more thing, previously I mentioned the lack of accessibility. Perhaps I was a bit abrupt there, but the elderly people, for example, I would like to say that here in Barcelona, we haven't had any problem as far as the elderly are concerned. The Catalan agency has always been available. So I just wanted to mention that I had forgotten before. Now I would like to ask our guest, Alexandra, if you want to add anything to that, anything that was mentioned by our colleagues. And then secondly, ask you as well, how do you see this compulsory arbitration that some countries already carry out, like Portugal? How would you see the possibility of that also to be used in other countries in the European Union? Is it easy? Is it not easy? How do you see that?
Thank you. A few remarks. I think this morning we focused on the discussion. We focused on compulsory arbitration, but we should not forget the goal. I think compulsory arbitration or mediation or ADR, it's a technique. What is the goal? The goal is to enhance mediation, to enhance awareness, to make sure that businesses trust ADR, that consumers go to ADR bodies to solve their problems. This is the goal we want to achieve. Compulsory mediation is a technique to achieve that goal, but it's not the only one. It has pros and cons. I can come back in a second. But it is one technique. I see equally important topics like, raising awareness with consumers and traders, making sure that they are well informed. I give you some good practices I've noticed across Europe. In Belgium, for example, several ADR entities organized a bus traveling around the country to present the services to consumers and to SMEs. So basically, the idea was that consumers will not come to us, SMEs will not come to us, companies will not come to us. We have to go to them. We have to meet them where they are. So they went on markets, city centers, even in far remote areas, even in poor, I would say even it was very important to go in poorer neighborhood to make them, to make sure that their services are known. And it was very effective. They did the same thing in the UK. It was an ADR bus traveling around the countries for 3 months, presenting the services, again, to consumers, to businesses. And it worked quite well. So there is, things that can be done from that angle in terms of raising awareness, educating traders, and so on and so forth. So this is another tool that can be used, raising awareness. Now, compulsory ADR. Personally, I think there is some misperception about compulsory ADR. For example, the question as to whether compulsory ADR is not meaningful because some traders, in any case, do not want to mediate. They will not start mediation because they don't believe in it, so it's not necessary to force them. I think this is a misperception because traders simply do not know how it works. So if at some point you do not require them to participate, at least to get informed, hey guys, this is how we work, this is the services that we offer, please have a look. They will not open the door. Okay, if you don't show them the way, they will not open the door. So I think making ADR mandatory, it's very important to build that trust, to build that knowledge with traders. So again, this is one thing. A second misperception is the idea that compulsory ADR would go against, access to courts. I think this has been solved by the Court of Justice in the past. For me, it's a debate we can have many times, but we have to go beyond at some point, I think. But what I want to stress is that compulsory ADR won't be the silver bullet. it won't solve anything, or everything. So it has to come with awareness-raising activities. It has to come with the quality of ADR entities. This is essential. The fact that ADR entities must act independently, but more than that, they should be perceived as acting independently, because the ADR entity can act independently if they are not perceived as acting independently by traders or consumers. This is a big issue. So ensuring that ADR entities met very high transparency, quality requirements, this is key. Ensuring that the work of ADR entities is under closed supervision by authorities also, making sure that they follow clear rules. This is key. I mean, there is this whole process of building trust. I know in many different countries, ADR has not taken up because consumers or traders do not believe in it. So we should not take it for granted. Even in my country, in France, so as I said, traders must sign up to an ADR bodies. But many of them will say, okay, I've signed up to an ADR bodies, that's it, huh? So don't come because I won't follow up. Okay. So you see the problem here. It's great to sign up, but they should sign up in good faith to make sure that they do, they start the process at least. So here you could, for example, see authorities checking that traders do actually participate in good faith. Do you attend a first meeting, for example? Do you try try the discussion? So this is not the silver bullet. It should be seen as a broader agenda, but it is definitely something important, as I said, in sectors where we know consumers are facing high detriment, like aviation, tourism. The number of complaints is incredible across Europe. So these are sectors key, I think. So yeah, thank you.
Moltes gràcies, molt interessant.
Thank you very much. Very interesting, all of these comments of how it's being done in other countries, what can be done, what should be done. Do any of you two have a comment on this? Otherwise, we can turn to the participation of the people that are here with us from the audience. We have time, so let's take advantage of that and share specific cases, observations, anything you want to share. Is there anyone that would like to participate, ask anything?
Aquí i aquí també, sí. Gràcies. Aprofito que tenim aquí 3 experts en el...
We have 3 experts, so let's take advantage of that. It's been very constructive, all of your participations. My question is for Alexandre. From your point of view, what do you think at the European level is the entity for mediation and arbitration that's doing the best job, and why?
Question.
It's a good one.
Do you want the entity or do you want the country? Even worse.
Both. Ideally both.
Okay. It's very difficult because even in one country, you have different sectors and the practices are different. Okay, I will respond. This is definitely not my country. But what I've seen, what makes a landscape efficient for traders and consumers? It's when you have a clearly defined NDR bodies consumers and traders can turn to. For example, in my country, in France, in the banking sector, you have nearly 50 or 60 ADR entities. It's a big mess, okay? In other countries, you have one ombudsman. So you have one clear point of contact traders and consumers can turn to. So it's much more effective in terms of visibility, how they work, in terms of, this is the best system. So a system where you have per sector one entity in charge of the complaint in this sector, plus for a residual ADR entity for the claims that are not falling into a specific areas. This is an architecture I see as as efficient. Now, I don't know which country is the best, but I can say a few words about the country that are not that good. In my country, again, we have I don't know why, this has been in place for 40 years, what we call in-house mediator, meaning ADR entities that are embedded into big banks, energy company. So you have, for example, a mediator for Engie, a mediator for Total, a mediator for SNCF, the Belgian railway company, and so on and so forth. Those mediators raise questions as to their independence, because in the eyes of consumers, they are not fully independent from the company they are embedded to. Even though they may be, in the eyes of consumers, this raised many issues. So to sum up, a clear architecture where an ADR identity is clearly visible, where the rules are clear, and as possible when there is no clear link with traders. Thank you. Sorry, I know
Thank you.
it's not a clear-cut answer, but
Polite. Per aquí teníem una altra...
Here we had another question in this row here. I am from the Balearic Islands, and I am in the foxholes every day. I know what it's like to fight, and I agree with the different presentations, because I think that one of the problems that our system has, our arbitration system has, or what it's lacking, is a lack of knowledge on the part of the society. I have had cases of speaking to people, colleagues of mine. The person voicing a claim calls and says, well, how's my situation going? And we say, well, it's going to be looked at by an arbitrator. And, well, the same word in Spanish is for a referee or a referee of a football match. And the person says, I don't know anything about football. So we tell them about the award, and they say, well, how much do I owe you? And, what if I said 1,000 euros? So I think that what Mr. Biard was saying, that is very important, of making our system more public, make people aware, and for there to be a trust that it's going to be handled by professionals. I have colleagues, friends that are lawyers, that when I began in the world of arbitration 4 years ago, they said to me, but you are like anarchists, aren't you? You don't have some kind of an order structure. They have presented specific cases, and you have to do a teaching aspect to inform people. That's one of the things we have to do. And as refers to the possible compulsory nature, I think up to a certain amount it should be the case. I think it should be mandatory, should be compulsory. But that's an idea I would love to debate. The way companies function today, I think perhaps there should be a different way of incentivizing them. Instead of looking at compulsory nature, rather looking at tax or fiscal benefits. Obviously, they are looking for that, and I'm not saying that I agree with that, but we could study the possibility of giving them tax breaks for participating in these actions. Yes, that's very interesting, and it's important to create a debate about this from the foxholes, and would it be feasible or not? Let's see what our say.
Just an anecdote from Belgium, just to explain this lack of trust. There is one ADR entity in Belgium called Service de Médiation pour les Consommateurs. So for consumers, it's a consumer mediation for consumers. And at the beginning, this name, consumer mediation for consumers, triggered many doubts among traders. So you want us to go to an entity called Mediation Services for Consumers, and you really believe that our claims will be handled in a fair and balanced way? Yes, we assure you it will be. Yeah. So they have to change a bit and explain a lot, a fact sheet, going to the people, explaining what they are doing. So even, the name was a bit misleading, confusing for them. So it's absolutely true. Thank you.
Yes, I would like to respond to that. It's even comical because it's like two sides, the consumer versus the company. We are consumer, but this can lead to people seeing it the wrong way. I have dictated certain awards to the consumer, and I've been told, I thought you were here to tell us that we were right. I am here so that your rights are not stepped on, but because you're a consumer doesn't mean you're always going to be right. And when these things happen, they say, well, you're in favor of the big companies, of the vendors, and you always, rule in their favor. And the companies think that we're in favor of the consumers, so they think that the consumer is always going to be right in our eyes. So we have to change the approach and change the perception that society has about us. Any comments? Yes, I just wanted to add that perhaps there are many ways of incentivating companies, but as I said before, what we need is this culture of arbitration, not just among the consumers. That's very important because they are the ones that come to us, and we have situations that are the same or even worse. And for the companies, we have to incentivize them by selling this as a rapid channel for dealing with these issues. That we can very quickly resolve situations more than going through court proceedings. So perhaps we have to sell it that way and not, maybe not tax breaks. That's my opinion, but we'll have to see once these are offered. Yes, do we have a microphone? Yes, from the foxholes as well. I'm in charge of consumer affairs in Sabadell, the city of Sabadell. And what I wanted to put forth is that we are talking a great deal about whether it's compulsory or not, but I think there's a long way to go in our current legal framework. We can't handle the avalanche that we have of a request for arbitration, and we're just not enough. There's not enough of us. And the current system, well, before we used to refer to other departments, but we're keeping lots of them now, and our consumers are well informed because first they go through the department, another department, and they are informed and they know where they're going. We have a very clear idea that the solution is arbitration, and mediation would be our second choice. And the arbitration councils that we have, well, perhaps all of Catalonia should work this way, so that is the entryway, that is the doorway. There are many, many cases, and this could be resolved with arbitration if there was a good structure and solution. We, as the board of Sabadell, we have to often not accept requests from other smaller municipalities nearby because we just don't have the manpower, we don't have the resources. Thank you.
Sí, senyor Garcia, volia fer una...
Yes, Mr. Garcia, would you want to ask a question or make a comment? Well, just two things. I'm not in favor of having to solve everything, but basically everything should be solved through tax benefits. I'm not in favor of that. But, well, Jordi and myself belong to a different generation. Any of you has studied what consumption is? What is ADR consumption for consumers at school? And this is not an evil question at all. I am asking because of the very clarifying contribution of Alexander on the dissemination of services and what we do. For a long time now, I'm not going to tell you for how many years I've been teaching at uni, but no one taught me. Perhaps I would have been given a different type of lecture back in the day, but we have Constitution, Article 51. Today we have spoken about remediation and compensation, and this dates back to the year 1978. So our people taught, and here I am incisive, our people taught anything at all about their consumer rights or systems to solve conflicts. It's not that I'm just, blaming others. It's quite the opposite. People don't know that there's a school for consumption in Catalonia. We have modules for young people, but not just for young people. I mean, there's technicians coming along, professionals of all sorts. So if we go to the proper roots, let's go to the roots. Let's speak about this. Let's have true educational modules so that people know what their rights are as citizens, because in the end, we're always getting to the same point. We all know that we're all consumers, but it's not just that. We're citizens. And what the rights that citizens must know nowadays is their relationship with producers, manufacturers, and service providers. But anyway, I would like to know, there's younger people than me, of course, and we're very fortunate for that, and I hope they are more aware. Thank you very much for the contribution. Is there anything else here? No, well, firstly, just following the comment from the colleague from Sabadell, if I'm not mistaken, we are coordinated with all the different boards. We help each other, and more so since the change in the regulation. So I know that we're working in a coordinated fashion, and if there's overbooking in a board, or a board is overburdened, then we've always, wanted to participate. I don't know if I interpreted your comment correctly, and I also wanted to make a couple of comments. I only want to say that the proposal, our defense proposal, the one that we mentioned yesterday for mandatory arbitration, already includes some actions to attend to these resources that will obviously needed. And I'm speaking about tax and also, the decongestion of court proceedings. But at any rate, the most relevant comment, is that sometimes we have the feeling that we listen to big companies and their arguments, but based on our experience, we have huge companies adhered to consumer arbitration that rarely reach arbitration proceedings, and whenever they do, what happens? Well, they have a huge maturity in customer service. The will that we have for mandatory arbitration is because we don't want to actually reach arbitration. We want for companies to be consequential, consistent, and mature in their customer service, as we want to have consequent and mature customers and users through education and great information campaigns. That would be ideal. It's not that we want to have mandatory arbitration per se. It's that we are in no doubt that that is the way of guaranteeing proper customer service and attention. So we have representatives here today from public utilities and big companies that can confirm what I'm saying. And as I was saying, there's funding as well, and what we need to do is to explore. Today's discussion basically was more to think about pros and cons, problems and issues, clearly, but this issue of resources would just be a different conference altogether. Are we thinking about the amount of public resources public institutions are using to attend to matters that should be responded or should be solved by big companies? We're using public resources, and this means we cannot deal with some other situations in other fields with consumers. And this is also a discussion that we could pay more attention to, perhaps on a different, in a different conference. But let's bear in mind that we do spend a lot of public resources to do this customer service for companies. Thank you very much. Did you want to add anything? Yes. As Marta was saying, well, thank you very much for the collaboration. And it is true that with the regulatory amendment or change, they've told us very frequently that they can help us out if we're overburdened. But I think that I'm not only speaking as president of the Sabadell board, but as other local boards. We would like to have solutions that didn't mean referring the cases of our consumers in Sabadell. We have a board in Sabadell. We want to have proper professionals to be able to serve our consumers that have gone through our mediation, through our services, and that we want to serve from our own board, despite the fact that we cannot do so now because, cases are piling up. Because, well, I also thank the Catalan government's task with the Catalan agency and their work with companies, because what Marta was saying about big companies that are mature, this might be the case because they had no conflicting nature. That's a paradox, isn't it? If this is already sensitive and they already solve these cases in customer service, they will have proper adherence. They'll have, but you won't have a conflicting character, a conflicting nature there. But we have sometimes abuse and lack of defense. And for many years, telephone operators were at the top of the list. They were adhered to many, and now you could solve them on a board. Now, with a drop in limitations, we are accessing a wide array of abuse. In energy companies, for instance, there were lots of abuse. There was lots of abuse, but there were so many limitations that the ball was just thrown between the different distributors and retailers. And, well, we've now accessed this pool of boards, and we have lots of cases, and we want to do them ourselves because they belong to our own municipality, but we don't have the resources. Sorry, I just don't want to just ranting out here. But this could only be done through this board, and we did things really well. So we shouldn't speak so much about the mandatory nature. I don't know what we'll do if it becomes mandatory. I mean, if we don't have any resources now, won't you just find a way? We can't go on because, as I was saying before, well, we could hold a different conference altogether, but this is the explanation, and, well, from the trenches, as you're saying. Mr. Garcia, just to finish, yes, if there's nothing more, yes, I'll state it in the closing, perhaps. I'm going back to a session, a roundtable of yesterday. Where is the money from the European funds allocated to the administration of justice and ADR, if it are requirements for proceedings? Money is not where it should be to avoid it arriving in the administration of justice. The goal has never been to solve, basically to not have everything going to justice. So you need to spend money beforehand. Secondly, and this is what I won't say later, the initial project that I know about when I arrived in the agency, this proposal of mandatory arbitration was not up to 2,000 euros. It was up to more. So some arguments about the why. Well, I asked Marilo to think about lowering that threshold. It was mentioned today, one person that has to perform an application of a claim of up to 1,000 euros, they better not perform the application, because if you cannot pay for the lawyer, and you mentioned the entire system and the proceedings for free, but it turns out that the only thing they can do is to go to an office, court of justice, where they will be giving a form that they need to fill out. Thank you very much for being facilitators and this accompaniment for people. But why? Because it is after 2,000 euros when you will need to have a prosecutor and a lawyer. So that's why lawyers are precisely devoted to this. And with this, I will finish. And I will try for our colleague from Sabadell to understand this, because I don't want to have too much success. I mean, if we now supply everything that is supplyable and up to 5,000 as in Portugal, we wouldn't have resources to take on this huge flood of claims. We can perhaps attempt at doing it up to 2,000. And as Marta Rovira was saying, if we have, well, I would love to make progress, but if we do, it will mean that we pay everything all together. And all together means that any resources made available to city councils, they also need to think about where to put the money in order to avoid these conflicts, and some other supra-municipal entities and, well, autonomous regions as well, and so on and so forth. Thank you very much, Mr. Garcia. We will finish this table with Alexander. He wanted to make a comment regarding this.
Just two quick concluding remarks. To respond to your first comment on the younger generation. I remember I did a study for one of the Belgium ADR entity a couple of years ago, and as part of this study, we look at the demographics, who are the consumers reaching out to the ADR entity. On average, those were people in their 50s, 55, white, male, healthy, So not really, what we thought was not really those consumers who might really need it the most. So there is a lot that can be done in this area. When it comes to reaching out to younger generation, I fully agree. I think it is a big challenge, I would say, for the consumer movement. We are doing a lot, to trying to see how we can make, consumer groups relevant for younger consumers. So again, we have to go there where there are schools. We have currently one trainee coming from, high school. We try to distill here and there, seeds, so that they know that we exist, what we can do, and so on and so forth. But there is a lot that should be done, and this is a huge challenge that we try to embrace. Second point, I learned a lot this morning, so thank you very much for sharing your practice. From my experience, I saw that we learn a lot from each other in this area. I learned a lot from my colleagues in Germany, in France, Belgium, in the UK also. So I really encourage you, and we can facilitate that if it's useful for you. Please get in touch. We will be happy to put you in touch with colleagues in other countries, because, okay, the legal framework might be different, the rules might be different, the techniques are the same. The issue, at the end of the day, are the same. The question of costs, the question of resources, they have exactly the same problems as you have. So we'll be happy to put you in touch with them so that they can share their experience, say, okay, this is how we do that, this is how we do it. It's not perfect, but this is how we do it. There are networks, of ADR entities at the EU level in the transport sector, finances sector, and so on and so forth. But, there also be contact with researchers, consumer groups working in this area. So I really believe in this sharing of knowledge, expertise, best practices to see what is out there. So I really encourage you to get in touch if you want to share your experience. We'll be happy to facilitate to some extent if it's possible. Thank you very much.
Moltes gràcies, moltes gràcies.
Thank you so much. And with this fabulous offer from Alexander, we will close this roundtable. Thank you very much, Enya and Jordi as well, for being here. And now we are on time, and it's been truly fruitful. Thank you very much.
Bé, doncs nosaltres, els nostres participants...
Okay, so our participants are getting ready, our next participants, and we will go to the second round table. Before the closing words of the director of the Catalan Agency of Consumer Affairs, we're speaking about lots of issues, lots of topics, and well, the next roundtable will be about is consumer arbitration a plus for businesses? Well, here we will have representatives from different companies and different professional fields. So we will now hear from María José Gallego Morales, Director of the Department of Consumers, Data and Legal Interception at MasOrange. Thank you for being here. Ernesto Alejandro Suárez Puga, Legal Counsel at CaixaBank, and Alex Mestre Perolada, President of the Council of the Association of Insurance Brokers. Thank you to the three of you. And our presenters were saying, our participants were saying that they're learning a lot. I am learning a lot. And after many years of relationship with the Catalan Agency of Consumer Affairs and doing awareness raising on mediation and arbitration, I'm actually learning, I continue learning a lot. So, as in the previous case, we all have a microphone, and what we'll do is to ask a general question, the same question for all, a common question, and then one for each, and then some more interventions that can further enrich this roundtable. So the first one is, how do you see this possibility, this proposal of having this mandatory arbitration with lower amounts that are lower than 2,000 euros, pros and cons as well? Well, thank you very much. Good morning, everyone. Thank you for inviting me. Thanks for the invitation by the Catalan Agency of Consumer Affairs and all the arbitration boards. It's a huge privilege to be with you here today and to have access to all the information, all the documents, all the different speeches that have taken place today. With such a high quality of speakers that we've had. Now it's up to the big companies to tell you or to show what has been our track record, why we're here, and why have we been, ever since the beginning, well, basically adhering to this measure, this mechanism, which is an additional guarantee for customers. Everything is around our customers nowadays, and it is very important to provide all the options. So before our customer leaves through court proceeding to claim, it is very important for them to rule out either more friendly mechanisms and procedures, closer mechanisms or with a bigger guarantee in many cases. We come from a world where historically telecom claims were our day-to-day, and the complexity of those of us who were selling telecom services, whether voice, SMS, email, email access, telephone, but not data, with permanence or without it, with or without installation. I mean, it was just a world of wonders. So that's where we come from. But we've made so much progress in terms of digitization, professionalization, of anticipate things, of doing responsible consumption in public administrations and also in private companies. The Catalan Agency of Consumer Affairs is just one example of great professionals behind consumer arbitration systems. Same thing might not have happened in other administrations where we've had to approach more, do more training, more awareness raising, more explanations. Basically, to take specific regulations and standards to the general consumer world, particularly in fields such as telecommunications with very specific standards. Nowadays, and now that practically all dispute resolutions are solved within the company, there's very little that actually gets to the consumer arbitration boards. There's things we miss, of course, but it's very few things. And the resolution times in the arbitration systems or mediation systems, well, 89% of cases were solved in 3 months' time. So this is record time and a guarantee for our consumers. And it is also a way of making them loyal, of having that customer become a sponsor in a way. Even if they've unsubscribed or even if they're leaving the company, they've had an experience, even within that field, that is still positive, that is close and professional and trustworthy. To the question, or to your question on whether it should be mandatory or not to establish this, well, this year's reform of the regulation has represented a very relevant paradigm because the field for almost 16 years now had been adhered with several constraints and limitations when it comes to serving or dealing with those matters that could be taken to the Catalan Agency of Consumer Affairs and other consumer entities in Spain. So it basically disappears. I believe it was actually on St. Valentine's Day when this limitation disappeared, and when a customer acquired a phone, we had to say that telephones were excluded. Anyway, that disappears, and having to face that situation throughout the year has been a true paradigm because we thought, oh my, what's going to happen to us? But not even close. It's been quite the opposite to what we thought. And as we, back in the day, wanted to be in the consumer arbitration system, this has meant one step forward and an additional guarantee. This is an additional guarantee. It's important for us to bear that in mind. And we're seeking the quality of services and differentiating elements and being there and being part of that and providing this to customers. It should be awarded in a way nowadays, and it needs to be a guarantee for our customers and for the companies that have this advantage in their conditions, on their websites, etc. That is my opinion. Should we make it mandatory? Well, we could think about it, but it does require a very detailed analysis of capacities. And I also believe in the possibility that there are some customers that, given the expertise of the situation or because they want to get a judge at some point, they want to go to civil court proceedings. And in some of the cases, limiting this or making it compulsory to go to the consumer arbitration process could even be limiting in rights. Now you can go to consumer arbitration, you can go to courts, they can mediate, they can have a wide array of solutions. Besides from the fact that customer service has changed, the customer no longer goes to a store or calls over the phone. There are chatbots, WhatsApps, endless mechanisms to get in touch with companies before thinking about a litigation or a dispute with a product or service that we trade with. And since we're not only marketing telecommunications, but other products around them, other products, services, goods, all this becomes even more complex. And this nature of the specific cases will not, it's not the same to sell energy or power than telecommunications with very specific regulations, or that you're marketing TV sets or smartphones or Dyson. I don't know. In my opinion, the consumer needs to have all possibilities, and we shouldn't be limiting in that respect. Thank you very much for your perspective, Maria Jose, and we move on to another representative who would explain his perspective on mandatory arbitration for this amount and pros and cons as well, and how you see things in your company. Thank you very much, Elisenda. I will be using the 3 languages. Thank you to the agency and everybody attending this conference. I believe that Maria Jose and the previous roundtables where we mentioned it with Alex, the level has been incredible. And one thing that we heard in the last one and that you mentioned here is cost. We've spoken a lot about, also legal investigative research. We can speak about legal, yes, but there's a thing about cost here. And you said it yourselves. The consumer arbitration system or protection system, you've said so, the cost has not disappeared. We've seen it. We've seen the cost of collapse. We are basically anticipating it. It's not disappearing. So Maria Jose was saying something that I believe that we've copied in the banking field. In the banking field, we come from where we come. We come from a financial crisis. And, well, basically, out of all crises, as Daniel was saying yesterday, you either learn and transform, or you just get carried away. So what have we learned? The solution of disputes with the consumer, you can take it as a conflict, or you can take it as an opportunity. So what do I believe arbitration did or was very good at, and generally speaking, ADRs, to having this brought into the company, within the company, your customer service is or does work as an arbitration process. I believe this is absolutely essential for big companies or companies that suffer from competitors' forces. I think that's basic, and this is something that must be done. And this is something that we attempt at doing. That's why I was saying it was a problem with cost. What happens here? That a very low amount claim, well, you might go into whether it's a financial issue or not. And our goal must be, if the money ends up in anybody's pocket, it should be my customer's pocket. That will make me differential. I need that customer. I want them to continue to be my customers. It's not just the financial crisis we're coming from. In my field, we have competition not from other banks, because there's less and less banks. Savings banks, well, we no longer have saving loans or saving banks here in Catalonia. But we do have the pressure of new technologies and the fintechs, new players basically that are putting a lot of pressure. And telephone operators already had them, but we didn't, and we need to be different. One difference, we work in financial flows. You sell experiences, basically, because you sell communication, you sell audiovisual, everybody wants to watch football. We were speaking about referees just a minute ago. But anyway, we sell savings and investment, and it's the most boring thing in the world, and I love it, and I love what I do, I love what my company does, but you will only be able to be different in price, not even in content. So, one great difference is customer service. That is also internalizing services. That's absolutely basic, and that's one of the things that we have learned. So what makes our customer service to operate as a consumer arbitration process? The fact that you can distinguish between those claims that you say, well, I do want to deal with this. I mean, I don't want this to get anywhere else. I mean, I prefer my customer to have their money back immediately. Or what in the Anglo-Saxon would be more like the class actions.
Most of the time with class actions or collective interest is that we don't have legal certainty over a given area. Parlava amb l'Àlex que una de les coses
We were talking about, Alex, one of the problems of cost is the cost of legal certainty. As an entity, we were speaking about massive litigation that we've had and, well, mortgage expenses, basically. You will say, yes, yes, that's the case with us too. Anyway, problem, mortgage expenses. So if you don't have a rule stating, hey, you need to come back after 5 years or after 10 years, if you don't have a response like that, you have claims piling up with opposing responses because you're told one thing at the beginning, then you're told a different thing, and all this is basically social cost. Social cost that is applied on the consumer. And this is just an example.
se ha hablado de la obligatoriedad.
In previous roundtables, we talked about the compulsory nature or not about arbitration, and we talked about the cost, because we spoke earlier that we are very much focused on regulation. Alexandra, I'm sure, is familiar with that because in Brussels they have a hyper-regulation. The regulation is a cost. It's a cost. And the cost, well, we are seeing that it's not disappearing. And I was saying that before to Isidore. It's passed on to the consumer and to the citizens. So I think we have to take on arbitration not just as protection of rights, but to remember that 51 of the Constitution, I'm a conservative, as Daniel spoke of yesterday. It speaks of the legitimate economic interests. Therefore, everything that costs in the system that are not well designed, it will be eventually paid for by consumers and citizens. One little thing, please don't change, if you could, from one language to another because it's complicated for the interpreters to skip back and forth. But thank you for it's very interesting to be able to change into all 3 languages, but we ask you, Ernesto. Now, Alex Mestre, we would like to know your opinion or the opinion of the sectors of the medical insurance companies. Thank you very much, Elisenda. Thanks to the General Directorate. First of all, before beginning, I would like to congratulate 2 great companies that are brave enough to be seated here, because we could, they could receive lots of blows here, and we are the last ones to speak today. After 2 very intense days, we have to make sure that there's warmth in our participation, so you remember it. Now, having said this, if these companies are here, it's because they must have done something right. And indirectly, and I personally congratulate them. Now, from the insurance sector, well, we are intermediaries, we are distributors that are part of the sale chain, chain of sales. In the world of insurance, it's quite intense, and can you imagine what it's like to explain it to a consumer? Well, all of us are citizens, all of us are consumers, and remember that there are some insurance that are compulsory, such as the car insurance, and I'm not here to explain that now, but you can imagine the problems we have there. Now, first question, Elisenda, the compulsory arbitration in this area? Yeah, sure, why not? We could consider that as something that we can take on, but there's a variable that we've heard quite a bit over these 2 days, and for me that becomes essential. And since we like to legislate, and since we have a legislative inflation, can we just talk about the time? Let's establish temporary criteria concerning when we're dealing with large entities, not the ones that do things the right way, but the others that are perhaps more troublesome, that there should be a compulsory period for responding, because time, as Shenia was saying from the organization Consumers, well, emotionally it disincentivates, it discourages. You have the consumer, we're all citizens and consumers, and we put them through stages. And that's the victory of Goliath. That's the victory of the system. Goliath and the entities that we face are Goliaths. Their business is time, apart from money. Obviously, they make lots of money. They have money for hiring great professionals that know how to distinguish or to talk about Article 51, about Article 24. But it's easier. Let's talk about time. Let's force them to answer in a certain period of time, a certain limit. And that everything is paralyzed, it's frozen during that period. So time can be a measure, a resource to stop this abandonment that occurs with many of the claims. So answering to your question, yes, without a doubt, while this arbitration, and as was explained before by the representative of the organization of consumers, if you have to go to a mediation, well, when you don't have mediation, then you go to arbitration. And if they happen to adhere to that, then you have to go to the court proceedings. And this consumer, this citizen, whether they're old, young, middle-aged, they grow tired, they grow weary. And it's true, I spoke of this with Ernesto, that there are large companies that are in litigation and they do business this way. Why does this business exist? Let's ask ourselves why the public system, with a clear lack of legislation, they provide too much content. Let me give you an example. In the royal decree that we have, 3/20, there are 3 or 4 articles. This is in the insurance sector. And you have to give a citizen before hiring, before contracting an insurance policy, etc., etc. It's all a scam. It's a lie. Why? Because this documentation that you send them, and Ernesto, tell me if I'm saying anything that's inappropriate, this documentation that we present to the consumer is more extensive than the contract itself. So if we are giving over information, too much information, I mean, it's like internet, the typical, if you can go to internet, but where and how, and this over information or too much information, well, what can I say? It's not the solution. The solution has to do with having resources. Most likely we heard that there will not be resources. However, to legislate concerning the amount of time that insurance companies or large corporations, companies have to answer a complaint, that's not that complicated. It's not difficult at all. Now, concerning the tax breaks, no, I agree with a colleague that spoke before that that's not a good idea. But let's penalize them in some way. Let's punish them. Let's squeeze them. And time is one of the main assets. We know that the justice system will not necessarily function. We shouldn't expect anything from the system in that sense. Let us Jose or Ernesto for is to understand the brilliant words of Maria Jose or Ernesto, for them to understand that the loyalty of their clients has to do with this arbitration at home, in-house, and that way it can keep your customers from fleeing. And then let's pressure them with time. There are insurance companies, I can't give their names because I'm in a public forum, that publicly, if you read their press notes, their press releases, they're telling you they're playing that same game, and that's relatively easy. The director of the Catalan agency, I don't know to what extent he can have an impact on this, but the regulations talk about a time period. Let's start here. Okay, time. This the time that we have to wait takes its toll on the consumers. That's one of the things that we have to work on. I wanted to ask Maria Jose, you have been working for a long time in arbitration, accompanying individuals. How would you define this experience? And what aspects do you find could be improved if you see the daily work that is done? I'm sure that you're very conscious of what needs to be improved to what needs to be changed to improve the service. Well, this is an important aspect today because the system of consumption is a very traditional one. The citizens, the segment that we work with, well, it is ever more specific. It's becoming younger, it's becoming older, becoming more vulnerable. And that personalization of the customer care is something that we have to watch out for. We have to tend to that. And we have to work not only in awareness and in promoting, but also to take a step further and to update the current system. I think it's a difficulty right now. We have to bring it, it's complicated to bring that to our young people, to have a resolution in the face of a conflict is essential. If they have a problem in a cafeteria, if they have a problem with their cell phone, they're not going to go to consumer arbitration. They don't want to talk with, they don't even want to talk with customer service. They want someone to tell them on WhatsApp how and they should change and their phone or whatever. That's the future. And these are our consumers. And we have to adapt to these individuals. And then the elderly, complex services, the bank, telecommunications, others. These are basic services, and we have to be well prepared. We have to be well prepared in the arbitration councils, of course, and the sensitivity and how we tend to the customers. The principle of responsibility must be present in the companies before the consumer tries to resolve that controversy to an intermediary, an entity. That's something that you cannot lose sight of. But in our case, we have 36 million customers, and there is a very small rate. But we can find that consumer, for whatever the reason, for the experience, because of the experience, they turn to the municipal office for the consumer of their city or town. They have that proximity, someone that they can trust, someone that's close. It's a public administration, and they can put forth their complaint. Well, in that point, the people that can be more vulnerable also have to have that care, which is close. We have direct lines of contact with the administration so that this continues, so that in a previous mediation, it can be resolved. Often we can find a case where the consumer, because of that principle of information that has to be made available in the pre-contractual information, we often squeeze them so much that the consumer accepts, they sign, they give their consent freely, but they really don't understand what it is. So this is something that has to be overcome. And we have to teach them, we have to promote this and adapt it to the type of profile that we're facing. We have to make all of these services much more personal, in my opinion. Let's go to Ernesto Suarez. In this case, as a company that does not adhere, do you have calculated, do you have statistic of economic and of customer satisfaction for small amounts, for example? Well, I was telling Maria Jose that one of the things that we do, well, we do things that are wrong. For example, one of the things that we didn't do well was the topic of the appointments to get away from the idea of people just walking in and meeting with someone, and we have gone to having to have appointments to meet with your advisor in the bank. So we're working on that, but in the area of litigation, as Maria Jose was saying, the personalization, we have to distinguish the type of situation, the legal proceeding, if the internal arbitration has failed us. So people turn to litigation. And we're not interested in that. We don't want litigation. The culture of my company, I know it's not the same in all, is to come to an agreement. And there is work that we do with supervisors that have helped us a great deal. Have you noticed that anything is coming? We ask them, because we have a series of proactive policies of having agreements. It's not just the policies, but in the world of consulting, it's very popular these days to talk about task force. We don't want controversies. We want the customer to be happy. We want quality, because we have competitors. If the competitors, are on your heels, then you have to make sure that their customers are happy. And it's difficult when there is a lot of competition, and litigation with a consumer is what we want to avoid. We prefer for the money to be in the hands of the consumer. This means there are two things. From the point of view of the bank, which is very boring, we have kind of standard claims, and we try to come to agreements of what we think may come out. For example, in the cost of mortgages before the prescription, in some cases, we were already returning it. Now we return everything. And the same is true with other types of litigations. And the opposite is true for us. Usually we have the client that's vulnerable because they don't pay. I don't know for a telephone company what the problem is, but in the case of the bank, it's because the client doesn't pay. You have to see this as lack of payment is something we need to avoid, and you have talked a lot about self-regulation, and I think that it's promoted. The best practice codes are promoted from the agency, and with the increase in mortgage rates, well, we have had to tend to that, and the arbitration is kind of in the middle. It is true that there is, in the financial sector, there is space for arbitration. in two areas. One is in insurance, because it's not as boring there. It's just not the deposit and the loan. Just as we speak in transport, well, the arbitrator can help there. But the second area is in the finance of linked consumption. If you don't choose correctly who you're financing to sell them consumption, if you don't give them service, you're the one that provides the service, so you have to choose your partners wisely. When we talk about offering different packages, well, if you've chosen wrongly, I think it's worthwhile there. In your case, Alex, I would like to know what aspects are the ones that the insurance companies are more reticent about of placing under arbitration, that makes it so difficult. This makes it so difficult. Yes, it's a complex setting, of course, and I would like to just make a brief comment. UNESPA is the Association of Insurance Companies, but it's the Association of Cats and Dogs, because all of the insurance companies don't have the same profile. None of them have the same profile. It's not the same as CaixaBank or Línea Directa, one that you see a lot on television. I don't even want to name them but all of you know what we're referring to when they say their slogan says something about there are insurance companies that confuse value with price, and that's truly a pillar of our system. You have to provide trust. You have to give them trust. That, if we're summarizing based only on price, then that's not a good thing. Now, giving that UNESPA, that association that brings them all together, I would like to be a fly on the wall and see how these different insurance companies come, agree things, how they come to agreements, how they cooperate, that they don't want any type of personal mediation, an insurance company that belongs to a bank, or that to compare that to another insurance company that is Swiss, and they think that this is the same in Switzerland, and this in Switzerland not alike in any way. So what can be the reticences? First of all, when we talk about arbitration and talk about being arbitrary, we have to watch out for that, because the arbitrator most likely will not have had a technical training, because in certain areas we have to have deep knowledge, and we could say the majority need to have some deep knowledge of the topic, and they are afraid of arbitrarity, of being arbitrary. Well, it's also included in our legal system. The legal system, the courts of first instance are, they're cute, but what are the advantages of these entities? That they can always turn to, they have money, they can go to second instance, courts of second instance. And they've been invited to, to see the company on the inside, and there the arbitrary nature is present, and I'm not talking about the other levels. Today is a good day to talk about resolutions at the highest level. But this is the problem that the insurance companies invent, to say no to arbitration, when it's totally false, in my opinion, because the mediators are all over. I think he's talking about brokers. The brokers are all over the country, So most likely there's a broker there in one town or another, and the brokers can offer that service. Why? Because the law requires us to follow certain education and training, and obviously, like in any situation, there are people that know more, there are people that know less, but the brokers, we can offer this knowledge, and we say, okay, we have some professionals that can be arbitrators on these issues. The insurance company, not all of them, but the majority, they don't like that. Why? Well, not because we have the vision that is pro-consumer. The customer, we always say that the customer is always right, but no, that's not the case. No, because to be right, you have to know the contract, you have to know about insurance, and usually the clients know very little about that. We lack, there's a shortage of training for the public, but where is the point of friction? This arbitrary nature that comes from the association, from the different insurance companies, and if we're talking up until 2,000 euros, then it's not that serious, but it won't be as expensive as what they say today, currently, and I will appeal to the law of agency of process. Well, yes, this should be online because there should be the availability of this information online, and the director can say, well, buy a few computers and send them to a few places, and I'm talking about computers and technology. That is the fear that there is from our perception, of course. This is not a dogma, but I do understand that when you are facing different entities, and, well, the entities that say no for no's sake. If we've lost this year 10 clients because we didn't know how to win over their loyalty, well, the solution is we've lost 10, let's get 13 new, so we're up 3, right? It's a question of numbers. And those that are in charge, well, their criteria, their obligations are not based on criteria of loyalty, but they are based on criteria of ones and zeros, but not like the computer people, not like IT, but rather the way it comes out on the profit and loss sheet. So that reticence, that resistance that exists for arbitration, I mean, we need to have meetings such as this so that everyone can discuss and share and hear. We have about 9 minutes, 10 minutes for questions. But the director wants to talk. But before, if you'd like to add anything, Maria Jose, before opening up for the audience, so they can make any comments, or Maria Jose, is there anything you'd like to add? No, just to ratify that the sector of telecommunications is complex, highly regulated, with very specific regulations such as the portability. Everything comes from the anti-monopoly board and the ministry, the general administrations. I mean, it's an area that is so regulated. Well, we would be the first ones in being reticent for there to be an arbitration system that could handle a conflict related, for example, to portability, that is to say, going from one company to another company. So for that reason, that being aware is so important, that when we prepare the defense, this happened to this client, we should also make it clear that we are regulated in those areas so that the arbitrator has all of the necessary information when he or she's going to decide and to give an award. And like I said, in my opinion, in sectors as highly regulated as ours, well, so this arbitration has to take into account all of these issues. It's not something that's done lightly. Yeah, that's my point of view. But yes, if one makes the effort to find a way it can be done, we have experience, and that's your opinion, right? What do you think, Ernest and Alex, before going to the audience? Well, what Maria Jose has said is very interesting, because something that happens to us with the configuration of my company, well, this is safe banking in France. That's a typical thing as well. And we have the problem that we submitted to certain processes that are outside of our own customer service, services that we have from Spain, from the Council on Fair Trade. This one of the problems that we have for, well, there's kind of a voice of God up front here. But one of the discussions that we need to clarify concerning this is if these resolutions, I mean, this is arbitration or it's not. Some are saying, no, 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 it's not. These are one of the things that we have, and I think that this type of conferences are very valuable, because these services, I don't know if we should take those competences to arbitration. I think that in our area of finances, that would be of great help. I would just take the floor from what Ernesto has said. This was born dead, and this is something that you have to be obsessed with. I said, let me see what argument has been given by the political group that added this and this figure was introduced. It's not only civil servants, but resources. So this authority is born dead, because since it costs money, it's not going to happen. But don't misinterpret what I'm saying. Don't misinterpret that we, the insurance brokers, are also, we're not against insurance companies. We want the customers to be happy with the insurance company, but we're the ones that suffer the most when we bring a customer and we tell them, relax, nothing will happen. And why? Well, because something always happens. Now, don't misinterpret me that we, the brokers, go against the insurance companies. No, we want things to go well for the insurance companies, for them to create products and for them to have channels that are as healthy and as correct as possible. And I take the floor from you again, the CNMV. Oh my God, the only thing I know how to say in English. What do you want me to say? There are inspectors that go out 4 days. I think 50% as they came in, they did the minimum and they went to the dark side. In other words, to the private sector. So you say, are you sure? Are you sure that our authorities on a state level have this capacity through these entities that are public entities, and the resolutions that are given will be necessary for the outcome? But if it's going to take more than 10 months, then it can't be. So I just wanted to clarify that the brokers are very interested in the insurance companies doing well. We are critical with some insurance companies that do their business some of them, confusing the word value with the word cost or price.
Aixecant la mà.
So we just have a couple of minutes for questions. Microphone here to the fourth row. Let's see if there's any contradicting opinions or if you want to add anything to what's been said. Good morning. I'm the secretary of the Catalan Agency for Consumer Affairs in El Penedès. Alejandro Suarez, could you please explain further about this internal arbitration process you spoke about? Because honestly, I'm not understanding. As far as I know, CaixaBank does not accept mediation or arbitration. There's not even customer defense, or they don't even respond to the requests that we send from the agency. Thank you very much. Well, one of the things that we used to have when we were a savings bank and then a bank was somebody to defend all the different savings banks. When almost all savings banks disappeared, we realized there was no sense in splitting all the tasks or the work. What happens is that the customer doesn't know where to go. So the arbitration role of our function is that one of the things that was reviewed in at the group after the crisis is that customer service regarding legal litigations. I'm not speaking about complaints now, which I believe this needs to be set apart. One thing is that you're arriving late, or we're speaking about quality complaints. That's in the commercial side of things. But as far as legal litigations go, there is a customer service independent from the commercial parts, and they cannot get any orders or instructions from it. What you're saying is difficult, the independence of the service itself, but we need to guarantee it, or at least attempt at guaranteeing it. That's how we do it. As far as mediation goes, I don't know whether you speak about mediation regarding complaints or claims, or with debt paybacks to customers. Sorry? Come again? I mean customer complaints. But is it a mediation once the complaint has been made or not? Prior to the apologies, but they're not using a microphone. It goes to mediation, yes. And we await a resolution or not? Have you received a resolution or not by us? Well, there's the time factor. Yes, that's true. What's the problem with what I was saying about legal certainty? And this is something that we've shared with the agency. Also, mortgage expenses. Is that what you're talking about? What are the cases? Yes. Yes, but mortgage expenses, yes, is that one of the... Yes, okay, so mortgage expenses. Or lands, well, not many left. A different thing that was done is that lands were removed from this. Yes, there's some topics. This is a specificity of the group. You know that many integrated entities had ended up in CaixaBank and not all followed the same. And this is what happened. Bankia would rather go for litigation, and we didn't. So there's also a time of adaptation. What happened with expenses? Well, when the character or the nature of expenses was described, for you to have an idea of the volume of internal arbitration cases, in the first month there was 100,000 claims. 100,000. Here you're speaking about 40,000 And it's true that we not always do things correctly, and that's our wish. And with mortgage expenses, there's a lot of reclaiming now because the amounts are very small, very low, but here documentation is of utmost importance. And after or when many years have gone by, getting documents is very difficult. And Maria Jose, what you said resonated, and it's basically that whenever we provide a response, so this is what the Supreme Court has ruled as a final conclusion or final ruling. If you have to explain this to a consumer, you better mention High Court ruling or Supreme Court ruling. And whenever we tell them they're right, well, but the only thing they understand is whether their money is in their account or not. Yes, that's true, and this happens. And with customers that could be or could benefit from the Code of Good Practices or with claims, there are some offerings of mediation, and very frequently they are not accepted when proactively we have attempted at doing things differently. And that's true, yes, and we need to answer. That's the thing that we need to improve. Yes, that's cannot be different. Any more questions? I had the microphone. I have the microphone. Sorry, I hadn't seen you. Yes, so this is just a very brief comment for Agnes as well. And regarding what the colleague said, Silvia Pardo, president of the ICAB service department. And the comment is that I was surprised at what you said about the policy in CaixaBank, because we all know that ever since 2008, courts collapsed, and not because of an agreement policy, not just in your banking entity, but some others as well. So I was surprised because we've had 52 Bs that has been collapsed both here in Madrid. So I'm surprised about this agreement policy when I've always had to go to legal proceedings. Even when we don't want it, we had to go to court, and it was just a legal matter. That's my only comment. Silvia, it's true, yes, we do have claims. I mean, let's not be confused here. The fact that we have an agreement policy does not mean that some things need to be taken to court. I don't want to go into that, but we have a very clear positioning of the loans referred to the mortgage index, as we were saying before. So what we do is that matters that are or have been legally solved, we don't want to go for litigation. In fact, this agreement policy, even when in a litigation we've tried to, well, one of the task force that we have is that whenever something is clear, it's not that you're receiving no claims, is basically the IRPH. Even with the IRPH, which is something that we will be going for litigation, even with that, there's been an agreement policy. People who've gone for Euribor, they've been offered the Euribor proactively. And this is a success case of this proactivity and providing quality to the customer. We have found that some initial IRPH have turned around when the Euribor has increased, and I've closed with a friend, a lawyer, a friend of mine, we've closed 10 cases in an afternoon. This is what I mean with an agreement policy. Okay, we have another question here. Julia Guimeral, Secretary of the Arbitration Board in Catalonia. We can't really hear you. So firstly, I would like to thank Mazorange and the telecommunication companies for being in consumer arbitration for 30 years now. And my question is for both representatives of those fields that have not gone for consumer arbitration. In terms of CaixaBank, I've seen the reluctance and resistance, and I don't really understand. On the one hand, they speak about things like banking expenses, but there are many more claims in banking services. My question is to the representative of the insurance agency and bank agency, would you accept individual arbitration proceedings until the moment when it is mandatory? These litigations, legal litigations that you're mentioning, we can solve them as based on law, yes, and yes, if and only if. I mean, we've been waiting for this for 30 years. And to the insurance guy, he said that the different insurance companies are very different. So those that are more prone to, I don't know, perhaps insurance brokers can be encouraging others to. This is something that was mentioned yesterday as well. With over 100,000 awards, I believe that at least 30 have been contested, and that is no prestige. Well, yes, we totally agree, but brokers are also part of, there's two types of brokers. They're the agents and the actual brokers. Agents are linked to the entity, and their civil liability is fully related to that of the insurance firm and not that of the brokers. So, well, we're all mediators besides the banking industry. Well, we're right in the middle. So, yes, without shadow of a doubt, but we need to find the insurance companies that are truly willing and want to do it. But yes, no doubt about that. And also approaching the Catalan agency in that sense, so that the Catalan agency knows that we're here. It's a two-way street. It's to see how we can basically generate these bonds. Well, this is not too bad, is it? No. He said it perfectly. The fact that we had not adhered does not mean that we have not done arbitration. We've done arbitration. Okay. So, Mr. Garcia. Mr. Garcia will be closing this session, yes, and this is something that I'm not going to actually mention during the closing session. Okay, so for starters, and personally, but not professionally, personally, I want to thank Ernesto for coming. You knew perfectly well where you were coming, but besides from being smart and very intellectually capable, he is a person who likes to dialogue. So now I'm going to launch a proposal. I don't want to set up a joint venture, but if you at CaixaBank provides this proposal, but you give it a wonderful name such as legal interception, and wait for it, general recommendation, Alex line. So whenever you get bored, look at Congress. Yesterday there was the official bulletin of the Congress approved on customer services. Time. I do confess that if 70% of what you will not spend in court you applied to complying with this law, and sorry for the translators, but if you do it in advance, before this is approved and before, I'm speaking about a year more or less, so if 70% is applied and the remaining 30% is applied to the compliance, so that lawyers that you have, I don't want to them not work. But if instead of going to court, they go to do prevention training, document drafting and preparation, and let's speak about accessible language. We are working here in a professional sector or industry. Well, welcome to the club. I'm sure that we can have more arbitrations before you fall off your horse, like Pablo or Paul and the parable. Well, I'm really fond of Alicia's, and she's already, I already put a ladder for her so she can get off her horse. Anyway, I want to thank you all. Alex, we've held a few meetings, and I knew you were going to be superb today. We are preparing the 2026 planning, and we want to perform control. What did you say? The general insurance, whatever? Oh my God, yeah, something like that. But we can see the different clauses of contracts, of policies, previous regulations, which is in the bulletin as well. Let's speak about that. Thank you very much. Thank you to all participants, Alex, Ernesto, and Maria Jose. So we're now closing this roundtable. It's been very interesting. Thank you for your participation. And for the closing, we will have the president of the Catalan Agency, or the director of the Catalan Agency of Consumer Affairs. So you have the floor. Well, we have the stand. I'm a modern guy now, so I'm taking notes in my smartphone. I would just used to leave my pens all around the place. And, well, besides intervening in the previous two roundtables, I'm going to do the closing. I'll try to be brief, but yeah, honestly, I don't have any papers with me. So first things first. Thank you very, very much for your attendance, participation, your contributions by all the speakers yesterday and today, all attendees, and thank you for the dialogue, proposal, ideas, all this atmosphere. Obviously, as Daniel was saying yesterday in the very suggestive presentation, this means there's a lot to do in terms of inclusion and the journey in which we are. But we're basically at a crossroads here. I like this. I like this crossroads better than the Spanish word encrucijada, because it has normally a negative component, and I believe we're not there. We need you now more than ever, because we've always needed you. We are going to miss Marilo hugely. She gave us lots of ideas here. Secondly, of course, we know that this proposal means a lot of money. I've already suggested many things that could be done. First one is to not spend money in the nothing and to work at the beginning. We've spoken about training, we've spoken about collaboration, many things that can be solved along the way. And regarding traveling the world, when I went to the first event I had to go to, I don't know whether Pilar Plaza is here with us, from Terrassa. Well, that was the 30th anniversary of that meeting, and I didn't speak about arbitration, but rather customer services. And that's where we need to spend our money. Some have been doing so for a while now, and I'm not looking at anyone. at anybody. And perhaps the time has come for others to do so. And this is the best tax incentive that we can throw at you, because you are saving 10 years of expenses that you would have in your court proceedings. And I'll finish, and it hasn't even been 10 minutes. Thank you once again. I wish you all the best until we meet again. Always here. Of course, the next session will also be held here. And very specifically, I want to thank all the colleagues from the agency that have worked and collaborated to celebrate this conference. It's been a truly positive, good conference to discuss, dialogue, and speak about consumer arbitration. Thank you, everyone.
Doncs hem arribat...
Okay, so we've reached the end. Thank you very much for your attendance, even if it's online through the streaming. Thank you for your participation, your contributions. It's been a true pleasure to share these days with you. Thank you to the Catalan Agency of Consumer Affairs. I've personally learned a lot, and I'm sure you have done so too. You've expressed your opinions, sometimes opposed, but everything is very nourishing. And before we leave, we have a bit of a meal outside, a lunch for you to enjoy. So we'll see you next time. Thank you very much.